All right. Morning, everyone. I'm glad that you guys were able to wake up. I heard that some people had visitors. We're just discussing the notion of import-export. You know, it's a joke. Okay, so welcome to the second day of what I'm sure you'll all agree with me has been an excellent conversation. We'll continue that conversation. Yesterday was a little more general and thematic. So we looked at sort of Canada in a broad way, Canada's engagement generally, 2 papers on that, and then we looked at the theme of health rights. Actually, from today onward, we're going to now become country-specific, not thematic. So we're going to become geo-specific. We're going to begin as we must with Nigeria, and we make no apologies for beginning with the giant of Africa, the single country whose GDP is larger than the next 5 combined. Just in case you don't understand what we mean by giant, so you digest it. The next 5 combined. The single country with a population that can drown half of the continent. I often joke when I teach Canadian immigration law with my students that, if every Zimbabwean comes here, it will just be, York University will accommodate them. But if one street in Lagos, Nigeria comes to Canada, Canadians may not find space to do agriculture anymore. So it is indeed a giant. So it's fitting that we'll start with the giant of Africa, Nigeria. I know that the Kenyans are jealous. There are no Ghanaians here. South Africans are very good friends, so they're not jealous. They're happy to be a close second. So we have an excellent panel, distinguished panel. We have Dr. Solomon Ukwebwe, distinguished scholar, who's a senior lecturer at the University of Benin, and I'm proud to say a proud alumnus of Osgoode Law School, of course. One of our most brilliant minds. He's going to speak on human rights discourses in Nigeria across time, trajectory, successes, and potentials for foreign engagement. We also have Dr. Udoka Nwosu Owie, my sister, from my own state, in Anambra. Certain people from places in the north called Kaduna and places like that I had to know where they are jealous. I can see them smiling. Who is a senior lecturer and former acting dean of Bayes University in Nigeria, in the capital. Another very sound scholar who's a lioness. Yes. Nigerians know what a lioness is. There are a number of great lions and lionesses here. You understand? There's only one university in Nigeria. University of Nigeria and others. Yes. University of Nigeria alumni are called lions and lionesses. We are lions academically, even though we tend to like meat. Ago in Igbo. So you're welcome, Dr. Weir.
Thank you.
We also have with us today. Sorry, she's going to present on, her title is In Search of Accountability, a critical assessment of the literature on the immunity of state officials in international law for human rights violations. Excuse me. And lastly, or clearly, not the leastly, we have my dear friend, Professor Paul Ocheje, who's of the University of Windsor, which is just 4 hours down the road. In Canada, 4 hours is just down the road to drive. Who is also a great Osgoode alumni, anytime I meet Polo, as I call him, I often tell the story of the first time we met. And it was in California, in Sonoma country. Those of you who know wine, know Sonoma country near San Francisco. That's where some of the best wines are made. Pinot Noirs, to be precise, usually. And we are in a 3 or 4 day thing. We're both doctoral students. This was before some of you were born, doctoral students. And we're there for 4 days and, basically ensconced together for 4 days on this farm outside San Francisco. Just debating for 4 days with a lot of other Africans and some Europeans, I guess. And every night, because that farm was a grape farm, they made wine. So every night, they told us that we could go into the barn, and it was endless supply of wine. So every night, we would drink wine till we were tired, or not tired, as the case may be. And so one day, we were drinking. As Nigerians know, our level don't rise. The level, Kenyans will say we are maintaining our wine. So I think it was around 11 p.m. I don't know if it was Paul or somebody else, started shouting, "It's a bear! It's a bear! It's a bear!" And all of us fled. Turned out it was a big dog. So when you have had that amount of wine, quantity of wine, the dog begins to look like a bear. And so that was the first conference at which we met many years ago, and we have remained good friends. Of course, a solid scholar. His title is Canadian-Nigerian Cooperation. He still uses that word, cooperation, which we dumped at the last conference, but we'll see. We had a huge debate on what engagement yesterday, whether the term is good. Remember at the first conference where you were, we also debated whether cooperation was good, whether there was any cooperation happening, in fact, a two-way kind of cooperation. In the area of anti-corruption, some Nigerians say it's anti-corruption. 1999 to 2011. Rhetoric and substance. That defines Nigeria, rhetoric and substance. All right? So with no further ado, I call on Dr. Kwebe to lead off. Again, as usual, 15 minutes, please. And as you all know, I'm very brutal in keeping time.
Thank you, the convener, Professor Kafo, and thank you as well, everybody who is here present. Professor Kafo has spoken about the giant of Africa. I'm not, unfortunately, going to make any disclosures to confirm that assessment. Rather, I'm going to speak about the potential for engagement in the area of adjudication of human rights claims. This is important because long before Canada had its Charter of Rights, Nigeria had a constitutional Bill of Rights. In actual fact, when in 1959, the Nigerian Bill of Rights was adopted, it was one of the earliest in the Commonwealth. There were only 3 other examples, and of the 3, only the Indian example was a little bit significant. The other 2 countries, Pakistan and Malaysia, were just in emergence. So it's interesting to also observe that the Nigerian model became the export model. Almost every African country in the Commonwealth that adopted the Bill of Rights in their independence constitution copied it from the Nigerian model. And not just only that alone, it was exported across the seas to the Caribbean. And again, almost every Caribbean nation in the Commonwealth that had a Bill of Rights in its independence constitution was again modeled, almost replicated verbatim from Nigerian model, except for Trinidad. Otherwise, the influence of the Nigerian Bill of Rights was quite extensive. But where did we get the Bill of Rights from ourselves? It was from the European Convention on Human Rights and Fundamental Freedoms of 1950, the first section of it. So we practically took every provision from that convention, that's the convention minus the later protocols, except for the right to marry. Every other one was copied into our own Bill of Rights. The point I want to make initially is that despite the early encounter with the Bill of Rights by Nigeria, the impact hasn't been felt at all in terms of the accretion of significant jurisprudence on the subject. And that's why I want to suggest that this is one area where there could be meaningful engagement between the judicial institutions of our country and Canada. I use the term here, dialogue, in preference to some other terms you see in the literature, like transplant, which may have a baggage of its own. I think dialogue implies a two-way traffic, and whatever one side can for the other will be part of this dialogue. But before I get to this point, let me just briefly account for the trajectory of constitutional rights adjudication in Nigeria over time, that is beginning from about 1960. Now, the first or the initial part was what I've called a tepid reception, whereby human rights in the Constitution had almost no impact on public policy. It seems, as a notable Nigerian scholar observed, that it's remarkable that almost every case handed down by the, almost every decision rather, handed down by the Nigerian Supreme Court between 1960 and 1963 was all went in favor of the government. And it's not a question of whether these decisions were wrong, but that it was just remarkable that every decision, as a matter of routine, was against the rights claim and in favor of government policy. And I've attempted to explain why this was so by analyzing some of the initial cases decided by the court. In particular, the case on freedom of expression, Chikobi, against the Director of Public Prosecutions. But I won't go into other details for this purpose, except to say that that initial case reflected the way the other cases went subsequently. And again, to quote Professor Wambuzi, people started to wonder by the mid-60s that what was the point of civil liberties being guaranteed by the Constitution if every violation of them, however flagrant seemingly, received the sanction of the courts. According to him, it began to look as if the courts were actively aiding politicians in the persecution of opponents and in the perversion of the Constitution. Confidence in their ability to decide political issues impartially was consequently undermined, and the position was eventually reached where there was a general disinclination to take political complaints to the court. The quotation in my text is longer than that, but I'll stop at this point. And other studies confirm that observation as well. And all the scholars who observed this initial trend during the first decade of the Bill of Rights in Nigeria made the same observation as Professor Owambuezi. And there are many ways you can account for this, but there's one I mentioned here, and it seems to be that the approach of the courts was quite legalistic, although that does not provide a complete explanation. But why this is important is because the way that rights claims are analyzed and the way that limitations on rights are rationalized will make a big difference if you are using the legalistic method and if you are using a more creative method. But at this time, Nigerian judges were more or less immersed in the tradition of British positivism, because that's the only education that they had anyway. Most of them were trained in British law schools, and this was the case, in fact, until about a decade and a half ago, as far as Supreme Court judges are concerned in particular. But the other explanations, or the additional explanations for this, including the capacity of the courts, political capacity of the courts to interfere in policy making. We have to acknowledge that at this time, in the 1960s, the only place where you could possibly get creative jurisprudence to emulate was probably the United States. And Nigerian judges did not appear to be familiar with American rights jurisprudence at this time. Instead, most of the precedents followed were British. At this time as well, Canada had nothing to offer at all. First, because the Canadian Bill of Rights is actually younger than the Nigerian Bill of Rights. The one year was enacted in 1960. And during the time of the Canadian Bill of Rights, that's pre the current period of the Charter, the judgments of the Canadian Supreme Court were just as legalistic and differential as the Nigerian court anyway. So Canada did not have much to offer, except one small body of jurisprudence that was developed by the Supreme Court in the 1950s called the Implied Rights Jurisprudence, which survived the Bill of Rights and was thought to be very creative, but the Nigerian court did not have pay any attention at all to that, or probably did not have access to it. Now, so this was the first phase, this legalistic differential attitude to the Bill of Rights. Now, by the mid-60s, there had been a very important political development in Nigeria. We had the military intervention, and so the civilian government, a constitutional government, was now replaced by a military dictatorship, which claimed absolute legislative powers. And initially, the courts were reluctant to challenge this, but by 1970, the Supreme Court, in a famous case, Lakomi against the Attorney General, actually tried to cut down this claim of the military dictatorship, only to find itself immediately reversed by the dictatorship successfully. This case, I think, is probably the high water point of the life of the Nigerian Supreme Court as far as rights decisions are concerned. Unfortunately, lawyers have not been very fair to the court in analyzing this case, because most times you find that analysis, or at least the initial analysis, tended to be very legalistic as well, looking at Kessin's doctrine and even claiming that the Supreme Court was wrong and so on and so forth, which I think is a pity. The court deserves far greater credit than he got. So now with the military dictatorship, things had reached a head. It was clear that law did not really matter anymore, and law would not restrain this dictatorship. And so by the 1980s, there was now a different path taken. And this path was more to find a way in which we could challenge this absolutism claimed by the military. And the way that this was done was to use international law. Now, to find some norms outside the domestic norms in order to challenge this absolute power of the claim by the military. Now, this was facilitated especially because at this time, Nigeria had domesticated the African Charter on Human and People's Rights. And this was in 1983, and this is very significant, really, because At the time Nigeria domesticated this charter, the African Charter was not even effective as a treaty yet. It stayed about 2.5 years before it became effective as a treaty. But it was domesticated almost promptly by Nigeria, and this was seen as an opportunity to challenge the government. And the way that the course went about it was to say that, you know what, this being a domestication of international law, it should be superior to the legislative claims of the military dictatorship. And even though that could be, we could argue about whether that's correct or not, but it was very effective, to the point that a commentator on the life of the African Charter, this is not in Nigerian at all, on the life of the African Charter, was able to conclude that it is ironic, but perhaps predictable, that the clearest illustration of the potential effect of the African Charter in domestic law is found in Nigeria under a military regime at the time of severe repression. So that's the irony, that this happened, but the reason is clear. It was a very important resource to challenge the military. So at this point, international law was co-opted, and this had immediate impact on the judiciary as well as the academy, because you now started to see that a lot of talk about international human rights this time. If we measure it by the output in law reviews, as well as law review titles, you will see that there was a tremendous impact, in fact. And so you not only saw articles on environmental rights, socio-economic rights, women's rights, and so on and so forth. You even saw specialized journals, law reviews, were now being published on aspects of these international human rights. For example, the Nigerian Institute of Advanced Legal Studies started publishing, to give just a few examples of the long list of journals published by the institute, a journal on health law and policy, a journal on the rights of persons with disability, a journal on law and development, journal on the rights of the child, journal on administration of justice and good governance, and so on and so forth. So this was rather remarkable. And all this is because of this change in trajectory that happened in the 80s. For the judiciary, activism was the immediate reward of this change. Even though today some of us will regard us as being in a state of post-activism for many reasons, which I won't go into at this point. But looking to Canada, what could we possibly gain by having an engagement on this issue of adjudicating rights claims? Because Canada has a very widely respected jurisprudence on of charter rights, and that is acknowledged worldwide, even outside the English-speaking world. Now, so what do we have to gain? I've identified 3 areas where this engagement could be very meaningful in terms of adjudication. The first is the issue of the priority of rights. I mean, let me explain this briefly. You know, the big challenge that we have, or that we have seen in the course of the application of the Nigerian Bill of Rights, is how do we justify the limitation of rights? When the government passes a law to restricts rights, how do we justify these restrictions? In other words, how do we determine whether the restrictions are proper or otherwise? Because our constitution says that only restrictions which are justifiable in a democratic society are permissible. You know, and this is very, very important, because it captures the European Convention approach to the matter, and the way that Canada and many other countries have gone about it now is to use the doctrine of proportionality. a doctrine which is not very well known in Nigerian jurisprudence yet, but it bears a closer examination. You know, the way that philosophers, for example, look at rights is different from the way that constitutional rights are analyzed. Now, philosophers, for example, using Donald Dworkin as an example, will look at rights as trumping policy. And that's why they arise. I mean, Dworkin says that if rights are truly rights in the strong sense, then they have to trump policy. And it doesn't matter, it says, whether the majority will be disadvantaged by that. But from the constitutional rights approach, or the lawyerly approach, we'll look at rights as optimizing requirements, to use the language of the German scholar who has examined the issue of constitutional rights and is regarded as having done a very important work in that area. And this requires that to determine whether a restriction is valid or not, we need to look at the suitability of the means adopted. We need to look at the necessity. In other words, is it the least costly approach in terms of infringement on the right? And then finally, we have to balance out rights. And this idea of balancing is what philosophers do not like at all when it comes to determining application of rights, because they look at rights as morally defined entitlements which trump other entitlements. And even though we are late coming on board this proportionality ship, it's already widely applied in several African countries. The examples I've cited from South Africa is obviously a very good example. Actually, it's a trend in the constitution. But even in other countries like Tanzania, even Zambia, and the African Commission, and many others also apply this as well. And this will give, of course, the basis for a principled application of the restriction clause in our Bill of Rights. So that's one thing we can gain. And Canada has developed a very sound jurisprudence under Section 1 of the Charter of Rights, which is proportionality-based jurisprudence. The second area that I think that this engagement will be profitable to Nigeria is on the rights of women as well as minorities. There are several statutory and constitutional protection of women's rights, particularly in recent years. For example, only last year, the Violence Against Persons Prohibition Act was enacted, which actually domesticates at once the United Nations General Assembly Declaration on the Elimination of Violence Against Women, as well as the protocol to the African Charter on the Rights of Women. So it's a very important development, but it's only applicable in the Federal Capital Territory, and so the impact is not widely felt yet. But there's also a Gender and Equal Opportunities Bill before the National Assembly. It was first introduced last year, and it was thrown out upon first reading, but now it survived second reading, and this time I think they will take it more seriously. But I'm looking for a jurisprudence to back this statutory framework in order to give them a meaningful life. Then, of course, finally, identify the cooperation between the course and the academy, course and law school, or course and legal commentators, which we find prominently in, say, Canada, United States, and we don't find a lot of that in Nigeria. I've tried to explain why the Canadian development, which started actually only in the 1970s, is how it evolved here, appointing judges who have an academic background. The institution of law clerks actually was revolutionary. The impact was so great that in the 1980s, the number of clerks was raised to 3. And so if you read, and I'm paraphrasing Richard Posner here. Richard Posner himself a senior, is a retired judge of the Court of Appeals. Richard Posner says that it's difficult today to distinguish the opinion of a Supreme Court judge from an assignment written for a professor by a student. It's almost the same. And it goes on to say that in fact it doesn't know, and it should know, because it's a senior judge and also a professor at the University of Chicago, that it doesn't know of any judge in the appellate courts in the United States who actually writes his own opinions, and that these opinions are drafted by these law clerks, and they sign them off and take responsibility for them, and so you find that there's a prolific reference to academic authorities in modern opinions, maybe sometimes unnecessary, but still it's able to bring together knowledge from far-flung sources. What are the challenges? In conclusion, let me just mention this. What are the challenges to this engagement? The first thing I observe is that the notion that matters of public policy are to be decided as claims of individual rights and decided conclusively as such is one which may not always be acceptable in Nigerian environment. Apart from the fact that there's a challenge about the fact that our Bill of Rights has over-replicated the European Convention, and therefore the whole notion of individual rights, which is what our Bill of Rights is about, the whole notion of individual rights tends to be a little bit out of sync with the African values of communal definition of the self. I mean, this debate is beyond for a long time. A little bit of it we heard yesterday, but the point is this: that the way that people look at individual rights here and press it to a logical end is probably not the way that we are going to do that in Nigeria. And there's a famous paper written by a Nigerian philosopher, Ifeanyi Mekiti, 1971, where if the convener will allow me, where he said that in the African understanding, in the African understanding, priority is given to duties which individuals owe to the collectivity, and their rights, whatever this may be, are seen as secondary to their set of duties. And if actually it goes more further to say that even the idea of personhood, which is so significant in the notion of individual rights, the idea of personhood, it says it's not the self, is the community that defines your person. And that's a very interesting. I won't want to go too far into it, but it takes us back to the Greek approach, Aristotle and all that, about the self and the polis. So that's one challenge. I hope I have been able to talk about that. Yes, 1 minute will be enough for me. The other challenge is international human rights norms, not widely applied, it is not effectively applied yet. And so one reason may be because judges are not familiar with international law. And we need to begin to have judges as well as lawyers who are going to use international law more creatively. And finally, judicial capacity. The capacity, of course, I'm not talking about whether judges take notes in longhand. I'm talking about the fact that what can judges really meaningfully do, in terms of being able to control the executive. And that has to do with the the political capital of courts, which seem to be limited still in our country. Thank you.
Thank Dr. Magwe for that presentation, which didn't disappoint. We now call on Dr. Weir. 15 minutes, please.
Good morning, Good morning, everyone. My paper is part of a wider study examining Canadian human rights engagement in Anglophone Africa, and it seeks to assess the literature on Canadian engagement with Nigeria on immunities of state officials for violations of human rights, with a view to ascertaining the nature and the attainment of the engagement, as well as the problems and prospects thereof. Now, the focus on the paper is on Nigeria for strategic reasons, as Professor Obi has made a lot of noise about the size of Nigeria, but very importantly about Nigeria's role in driving and shaping human rights discourse and praxis in Africa, including the issue of accountability of state officials for human rights violations within the African continent. And this paper is linked to the past project on Canadian-Nigerian human rights engagement, because international accountability of state officials was one of the optics through which Nigeria's contributions to human rights praxis was assessed, as well as Canada and Nigeria's human rights engagement on the establishment of the International Criminal Court and the regime of the International Criminal Court. Now, in terms of methodology, the paper adopts an interdisciplinary approach, drawing from law, international law, legal theory, international relations, and politics. And at this juncture, I would like to make a couple of introductory points and caveats as well. Now, at the core of the discourse is the principle of sovereignty, such that no state can claim legal superiority over the other. Secondly, immunity is not a freestanding principle of international law, but rather it is an exemption to the jurisdictional competence, be it the adjudicatory or enforcement jurisdiction of a court or tribunal. And then thirdly, a distinction is made as to the sovereign immunity entitlements of states into three different genres. So we have state immunity, diplomatic immunity, and state official immunity. With regards to state immunity and diplomatic immunity, they are governed both by customary international law as well as convention treaty law, whereas the last, state official immunity, which this paper is dealing with, is governed exclusively by international custom. Also, with regard to state official immunity, international custom adopts a bifurcated approach to the immunity of officials. So it recognizes absolute personal immunity for serving officials and the limited functional or material immunity for former officials. I would also want to make a distinction, or I would also want to say that it's important that a distinction is made between criminal and civil responsibility for the purposes of accountability. Now, this paper is focused with criminal responsibility, and why I say it's important to make such a distinction is because the civil proceedings against state officials necessarily impede the state itself. So when it is a civil proceedings against a state official for accountability, it is the state itself that is being called to answer, as against when it's a criminal proceedings, then it is individual criminal responsibility we're looking at. And because that distinction is made and we're focusing on the individual criminal responsibility. So decisions of the Canadian Supreme Court in two cases, Buzari versus Islamic Republic of Iran, as well as Kazemi Estate versus Islamic Republic of Iran, will not form part of the discourse in this paper. And finally, the analysis in this paper is limited to human rights within the contemplation of international criminal law, that is torture, war crimes, crimes against humanity, genocide, and aggression. So basically, human rights that have been criminalized. And this paper is not looking at other human rights are outside the normative contemplation of the paper. And this paper is not looking at the content of these rights that have been mentioned, but rather the issue, the interface between immunity and these rights, and that is seen in the enforcement of these rights. Immunity of state officials remains important, very, very controversial, and contemporary, with issues ranging from the theoretical foundations of immunity to what type of state officials would benefit from immunity, the nature of the immunities, and whether there is a conflict between immunities and human rights, and whether there can be immunity for state officials for violations of human rights. Now, the focus of this paper is on the last two issues, that is, the more common arguments that are made that there is a conflict between immunities and human rights, and whether there should be immunity for state officials for violation of human rights. And to this end, the paper is divided into 6 sections. Now, my introduction inaugurates the examination to be undertaken and gives a background to the paper by highlighting the anxieties in the discourse of immunities of state officials for human rights violations. Section 2 of my paper sets out the problem concerning the interface between a system of immunities and a system of human rights by showing how immunities of state officials is a human rights issue. The third section is an assessment of some of the literature on whether there can be immunity for human rights violations. And the fourth assesses Canadian-Nigerian human rights engagement through the optics of the ICC, the International Criminal Court regime, and the involvement of Nigeria in the trial of Charles Taylor by the Special Court for Sierra Leone, and the establishment of the Extraordinary African Chambers in the courts of Senegal. And in section 5, my paper would examine the nature, attainments, the problems and prospects of the engagement or its lack, as the case may be, and section 6 will conclude the paper. But I want to start by problematizing the issue. Now, the notion of immunity of states and their officials originated in classical positivist international law, at a time when states were recognized as the only subject of international law, and that the direct protection of individuals had yet to materialize into the focus of international law. But with the development of human rights, the evolution of international law has witnessed an individual-oriented approach as against its traditional state-centricism. And a consequence of immunity, which is an exemption of a state or the officials of a state from the jurisdiction of a court, again, the adjudicatory or the enforcement jurisdiction of a court or tribunal, is the challenge or inhibition of the enforcement of human rights. Now, the idea is that human rights encounter an enforcement crisis where immunities are involved. Now, this is because human rights seeks to expand the adjudicatory competence of courts and tribunals, whereas immunity seeks to limit it seeks to exempt certain persons from the adjudicatory competence of a court or a tribunal, and thereby resulting in a seeming doctrinal conflict between the system of immunities and between a system of human rights. Now, at the heart of the discourse in the paper are two very different perspectives. First, the classic positivist state-centric view of international law, as I said earlier, that the duties and rights enunciated in human rights instruments devolve on states, and as such, that international rules are to be interpreted against the backdrop of the position of the individual, which is that individuals are incapable of acquiring direct rights in international law. And based on this classical view of international law, immunities of states and their officials are to be respected always, even when human rights violations are in issue. On the other hand, there is the naturalist progressive human rights perspective of international law, which basically says that in the absence of any rule stipulating that there is no rule that stipulates that only states can acquire direct rights and duties in international law. And therefore, nothing stops individuals and organizations from assuming direct rights in international law, especially in view of the trend of recognizing the increasing importance of non-state actors. And according to this view, human rights must prevail even where must prevail over immunities, especially in view of the fact that certain norms of human rights, certain human rights norms have assumed a peremptory status in international law, what are called norms of jus cogens, for which there can be no derogation from. Now, in my paper, I proceed to deconstruct the conflict. And at the heart of the deconstruction of the conflict is the sovereignty of states as the common denominator between a system of immunities and a system of human rights. And secondly, it is inherent in the notion of the term conflict that there is a contradiction, an opposition, that two things contradict themselves. And thirdly, for a conflict to arise between two norms, I argue that those norms must be of the same character. Now, immunity is procedural in nature because what it does is to exempt from the adjudicatory jurisdiction of a court. It does not negate liability, and therefore it is procedural in nature, whereas human rights are substantive. So the character of the two norms are different, and therefore there really is no conflict between the two of them. All that it means is not an absence of liability. All that it means is an absence of jurisdiction. And as one of the leading commentators, Hazel Fox, in this area says, is that it merely diverts, you would simply have to find another way to resolve the issue. Now, saying that there is no conflict between the two norms does not mean that immunity does not present a challenge to the enforcement of human rights. And the next issue I want to look at is whether then there can be immunity for state officials for human rights violations. Now, this issue is one that has pitched legal scholars against each other. It's a very contested and heated area. That's not fair, Prof. I've barely had 5 minutes. No, I haven't. Okay. So it has pitted scholars against themselves. Now, let me quickly move to Canadian-Nigerian engagements on immunities of state officials for human rights violations. Now, preliminary findings from the desk review do not suggest engagements between the two countries in this area. At best, what is evident from a review of the literature is the involvement of both countries independently of each other. There's no structured or conscious or concerted effort at engagement in the area. And the involvement of these countries is seen. The first angle is from the establishment of the International Criminal Court and its regime. And why I say this is important is because the Rome Statute of the International Criminal Court makes irrelevant the official positions so it removes the immunities of state officials. And then another involvement, the Rome Statute removes the immunity of state officials, and both Canada and Nigeria are members, are state parties to the Rome Statute of the ICC and played important roles. They belong to two different ideological blocs at the negotiation stage of the Rome Statute. Another important involvement is that of Nigeria in the trial of Charles Taylor by the Special Court for Sierra Leone, because Nigeria had, despite granting Charles Taylor asylum, in the absence of an extradition agreement, as well as without being an extradition agreement with Liberia, and without being bound by the statute of the Special Court of Sierra Leone, surrendered Charles Taylor to Liberia for trial by the Special Court, and Charles Taylor was convicted and sentenced to 50 years imprisonment. And as well as the involvement of Nigeria and the Extraordinary African Chambers in the courts of Senegal, which was established to try former head of state of Chad, Hissene Habre, and which convicted him in May 2016 and sentenced him to life imprisonment. Nigeria's involvement in the at the African Union level, heads of government and heads of state, as well as the Committee of Eminent African Jurists in trying to find an African solution to this issue. And again, the ILC, the International Law Commission, there is the position of both countries, both Nigeria as well as Canada, in support of the position that state officials enjoy absolute personal immunity. But as I said, in the main, the research so far does not show any engagement between the two countries in this area in practice. The practice I've mentioned, as well as in the course of negotiations in international conferences leading up to the establishment of the ICC, as well as in the work of the International Law Commission or at the UN General Assembly, or even through civil society organizations and NGOs, there is nothing evident here. Now, the problem of the engagement is the absence of one. That's the biggest problem. And in the absence of one, again, one of the things we've seen is that the conduct of both states have been inconsistent. Despite what I said about the involvement, there have been inconsistent practices of both states. So, for example, Nigeria that was involved in the ICC is the same Nigeria that did not arrest al-Bashir. And the Nigerian government, even despite surrendering Charles Taylor at the domestic level, had contested an application by victims of Taylor-sponsored human rights violations, saying that the decision to grant Taylor immunity was one that was not amenable to judicial review. Again, even Canada and its not having ratified the Kampala Amendment on the crime of aggression. Now, on the flip side to the problem of an absence of engagement is that the absence of engagement portends prospects for engagement. And it is in these prospects that some of the problems of the inconsistency in practice might be addressed. And the need for this engagement comes at an important time with the current negotiations and debates at the International Law Commission towards the drafting of articles on the immunity of state officials from foreign criminal jurisdiction. Also, the recent threats of some African states to withdraw from the ICC, for example, South Africa, Burundi, and Gambia, with the refusal of African states en masse, including Nigeria and Nigeria and South Africa, to arrest al-Bashir, with increasing talks about establishing a criminal chamber in the African Court of Justice, things that make some of the contemporary developments that make or that give impetus to prospects for engagement as well. And with the efforts of the ILC in the formulation of these principles, the conduct and views of states is necessarily implicated, and this also necessitates engagements between Nigeria and Canada as important stakeholders and participants. Now, by way of a conclusion, my paper set out to critically assess the literature on Canadian and Nigerian human rights engagements with a view to ascertaining the nature of the engagements, the prospects, problems, and prospects. And preliminary findings do not show any structured or coherent engagement between both countries, as the participation in this area has been devoid of any conscious and concerted efforts at engagement. Contemporary developments in the area, however, show opportunities for engagement. And finally, a research agenda would include identifying how Canada and Nigeria can partner in the area of immunities of state officials for human rights violations and the nature of such partnerships. And this would open up the space for knowledge exchange that would inform policy and practice across the global North and South divide. Thank you very much.
Thank you for keeping
Forced
to
to be.
time. Gladdens my heart when we keep to time. So thank you so much. That was excellent, Dr. Weir. We'll now move on to Professor Paul Ocheja.
Thank you very much. And good morning, everyone. I regret I was not here yesterday. I would have loved to be here. But I see a lot of faces that I've seen before, and it's a happy reunion. So those of us who were here 2 years ago, was it? All right, to broach these issues. My paper will be relatively short compared to the ones you've heard. I intend to deal just with the corruption aspect of the engagement between Nigeria and Canada. To put it bluntly, there has not been a lot of engagement in that regard. And so I would define corruption broadly as abuse of power. And we all know the connection between abuse of power and poverty. All right. The United Nations has recognized that the greatest obstacle to development in Nigeria is lack of transparency, corruption, and abuse of power. It is not as if that evil is directly under control or effectively under control in Canada, even though we don't hear much in the news about corruption in Canada. There are checks and balances. There is a concerted control through legislation of corruption in Canada. However, we will find that Canadian actors, corporate actors especially, are not laggards when it comes to corruption when they do business outside of Canada. And the whole point of this engagement in human rights across the world is that by cooperating and by showing examples, we'll be able to promote human rights, be able to give some lessons which newer democracies can learn from. But unfortunately, in the area of anti-corruption, Canada is very quiet, very reticent. In fact, in the area of oil and gas exploitation and mining outside of Canada, Canadian companies rank, let us just say they hold their own among other companies of the world in terms of lack of transparency and abuse of power in the in the implementation of their strategies for business control in these countries. One example I have is a company called Acres. It's a Canadian company that was carrying out a water supply project in Lesotho, in the Lesotho Highlands, which got directly involved in bribing officials of the Lesotho government so that corners could be cut in terms of the implementation of the project. Acres was actually sued and, in Canada, and a lot of award was made against Acres. But Acres is by far, when I look at the activities of companies, Acres is by far one of the benevolent ones, one of the least aggressive ones when you come to how Canadian companies behave outside of Canada and what examples they are showing the newer democracies. Manitoba Hydro had its contract cancelled in Nigeria for lack of transparency. Manitoba Hydro was going to be involved in the power industry, was going to offer its services to Nigeria in the area of provision of power and electricity and so on. But a lot of people are still confounded today about how Manitoba Hydro went about obtaining the contract for the provision of electricity. Eventually, after a hue and cry was raised, the contract was cancelled. Now, there's nothing worse internationally than to be told, physician, heal thyself. I don't know whether the Canadian government knows the impact of most of its policy leanings when it comes to human rights and abuse of power internationally. All right? But it does have a lot of impact, because Canada is a very important country. It did not get to where it is now through corruption. Canada, has been able to manage its resources well, relatively well, compared to many other countries. For example, it did not fritter away its resources in search of imperial expansion, which is much more than you can say for our southern neighbors, But it has most of the time been able to judiciously manage the resources that it has in a relatively transparent way. And Canada's reticence on the matter of corruption does a lot of damage to the promotion of human rights. Because, I mean, if corruption is characterized as the greatest impediment to development in a country like Nigeria, which has the resources which people generally agree are enough to help in his effort to develop his country, to develop itself as a country, then if Canada cares actually about what happens all over the world and how corruption has frustrated all of these efforts, Canada must speak out, and let its voice be heard. It has not taken a stand on this corruption matter. Canada continues to do business with a lot of countries that are internationally recognized as corrupt, but it allows its attitude on the matter of corruption to be mediated by what business prospects are there for Canadian companies. You talk about China, everyone knows that in spite of the economic progress that China has made lately, it is still enmeshed in serious corruption. You talk about countries of Latin America like Guatemala, Peru, Colombia, Honduras. All of those countries suffer from the kind of corruption that has become the big issue in Nigeria. Yet, Canada does business with these people. With nary an eyebrow raised regarding what is going on in those countries. And I bet you the details are not all out, but if you look at them, you will see that corruption, there's a lot of corruption in the background of most of these agreements that Canada has entered into lately. There are 9 free trade deals that Canada has concluded lately. There are 2 that are almost been completed, and there are more coming in the pipeline. All right. In none of these documents, in none of these free trade deals, would you find anything mentioned about lack of transparency, which is a fancy word for corruption. Nobody does that, in Canada. And in all of the discussions that you go through as background to the conclusion of these deals, you will not see anything about abuse of human rights and how people need to do human rights impact assessment of all trade deals if we are going to be consistent in our advocacy against corruption. None of this is ever mentioned. And so it leaves us wondering just what promotion of human rights means to Canada. My approach to corruption is to make it very broad. There are no specifics in terms of engagement with Nigeria that I can show you. Even in the case of the Manitoba Hydro, whose contract was cancelled, we have not seen the details up to today, about how this came to be cancelled and what the problem was. Even though we see anecdotal evidence of peddling of influence, on the side of Manitoba Hydro. Canada has tried to approach the issue of corporate social responsibility, which is another way that some countries have tried to look into the issue of corruption. If you are busy spreading corruption, and corruption has been identified as one of the most difficult impediments to development in Africa, then of course it becomes a serious issue. Your human rights position becomes suspect. People begin to doubt whether you are sincere. People begin to tell you to go heal yourself first before you start looking closely at what is happening to us. People begin to wonder whether you even know what the local circumstances are and how much of a Herculean task you have set for yourself. Incidentally, Nigeria, in the areas where Canadian companies specialize, Nigeria has a lot of problems. Oil production, extraction of oil and gas, all right? In Canada itself, we see an example of a country that is not overly bothered about human rights, especially when it collides with business. All right, and so one of Canada's objectives under the Canada Business Plan, which is always what they do almost every year or a few years at interval, they do. Canada has identified economic growth and prosperity as its objective, in terms of business, in terms of economic development. Economic growth is the objective. And we all know that traditionally, when economic growth is the issue, most liberal economies refuse to allow human rights to intervene or, to prevent or to be an impediment to the growth or to the businesses of corporations. In Canada, the Aboriginal people have been treated very unfairly when it comes to the disposition or the extraction of resources from their territories. Canada recently has embarked on what it calls reconciliation. Well, we hope that reconciliation goes to its logical conclusion. But otherwise, when it comes to business, Canada has not allowed the human rights of Aboriginal people to stand in the way of progress. The new pipeline cutting through British Columbia to the United States is one example. It is envisaged or projected that it would cross over 1,000 rivers and streams, all of which are in the First Nations territories. And of course, the First Nations live on fishing and hunting. These are their mainstays. And when all of these rivers and forests are destroyed in the name of economic progress, Aboriginal people will be without livelihood. And of course, what is human rights? What is, the United Nations has often repeated that people must not be deprived of their livelihoods, their means of sustenance. In Nigeria, unfortunately, this is going on, with complaints every day about oil pollution, how it is eliminating or destroying people's means of livelihood. The same thing is happening here. And I wonder, is it going to be physician heal thyself again, as far as Canada is concerned, or will Canada be able to talk freely on behalf of human rights protection in the world? A very essential aspect of which is lack of transparency and, corruption, going on in many of these countries. So I think I'll bring it to a close here. I've been given the signal to stop. I didn't know I'd spoken up to 15 minutes already. It's not the Nigerian thing, is it? Okay. So thank you very much for listening. Thank you.
Thank you so much, all the speakers, for keeping to time. Very essential. We'll now call on the discussants, beginning with Dr. Badaru, Boluwa Badaru. You have 5 minutes, please. Yes.
Only
5 minutes.
I'll try. So I think thank you to all the presenters. I was able to read the papers of Dr. Ukwegwe and Dr. Owe, and even though I have not read Professor Ocheji's paper, it was, enlightening to read and to hear the presentation. So first I'll address Dr. Ukwegwe's paper. I think your paper did a good job, in tracing the history and the attitude of the Nigerian Supreme Court to human rights, as you said in the decision in Director of Public Prosecutions and OBI, how the court was, not very concerned with exploring the scope of the right to freedom, but preferred to focus on the fact that he deemed the publication to be seditious under criminal law. Now, for me, this highlighted the question, which I think you talked about later on, the question of the issue of balancing of rights. And we can also see from the paper how the court's inclination is to focus on the law as it is and not on the law as it ought to be. And I could actually draw a parallel between this point that you made and the other point, the similar point made in Dr. OS paper by some authors who argue that the courts, in applying the law as it is, should take into consideration the lex ferenda so as to ensure remedy for individual violations of human rights norms. Now, when you discuss the emergence of the judicial activism in Nigeria, you made the point that the work of advocacy groups who began placing matters regarding human rights protection before the courts were funded by foreign donors, including Canadian agency. I think it would be beneficial if you could, specifically identify who these donors are and what their involvements were, so that we can, unpack, these sites of engagement, and we can analyze what impact and the outcomes were. And another thing is, perhaps it's a controversial point to raise, but you began your introduction by talking about the fact that Canada's human rights jurisprudence is highly regarded worldwide, and its influence on Nigerian courts has been limited. I wonder if we can, based on what we discussed, some of the discussions yesterday, if we could explore whether Canada can actually draw benefits from Nigerian jurisprudence or practice, or at least engage in some meaningful, cross-cultural reflections. Or is the nature of engagement only such that Canada should be giving and Nigeria should be receiving? I think we should perhaps, look into that. And then the last point says, on the cooperation between the courts and the academy, which you raised, I think maybe we need to, you may think about shifting the focus from education of the judges as a way of channeling inputs from the academy, and rather focus maybe on the education and training of the lawyers in Nigeria, because really when you read the decisions of the judges in Nigeria, most of them are cut and paste from the briefs of argument placed before them. And so maybe the site of engagement really would be to, even the lawyers who are writing the briefs before if you cite academic articles as a lawyer, the chances of the judges, citing them as well would follow suit. So maybe this is another site of engagement which we could look at as to influencing the judiciary. But I thank you for your paper, and I look forward to reading the final version. And now to Dr. Owens. I really enjoyed your paper. It's very well researched, very engaging. And one of the premises of your arguments, you said, talking about the nature of Canadian engagements. Okay. Let me wrap it up quickly. I think two points. You said humility is a procedural bar, and it's not substantive. But one inquiry that came to my mind is whether it has been explored that oftentimes, because of the lingering influences of these officials in question in their states, it's almost perhaps impossible, in fact, to make them accountable in the domestic court. And to this extent, the implication of immunity of such officials is that it's almost like a get out of jail free card, because the chances of them being prosecuted in their states are very unlikely. So, so are we looking at, even though it seems procedural, it could actually be substantive, because maybe the only way they could ever be tried and brought accountable would be, by being tried in a foreign jurisdiction. Okay, so I think in reading the paper, I observed that much of the paper focused on Nigerians' handling of the issue of immunities, with foreign officials in Nigeria or other countries in Africa. But you might want to include in the paper, so that we can compare approaches, some perspective of how Canada has approached the same issue of immunities for foreign officials for human rights violations. And even though, if there is not, just highlight that fact that it hasn't happened, or Canada has not had to deal with it, so that we can compare and see how the two countries can engage. I have 1 minute, and I'm just going to have a talk about Professor Ucheji. Professor Ucheji, it's an honor to discuss your paper, being that you were my external supervisor. So, so just one. So I just thought, have you considered extraterritorial human rights obligations? Because you talk about how Canada is very reticent in responding to the actions of its corporate of corporations outside. So I thought maybe, is this something maybe we could look into, that whether Canada, maybe this can open on the debate, if we research into the issue of extraterritorial human rights obligations, and perhaps engage with the Canadian state with that. Maybe the Canadian state will be forced, to address this issue and then engage with it. Thank you very much.
All right. Thank you, Dr. Badaru, for those incisive comments. We'll now ask Ms. Raina Zama who's a doctoral candidate here, to intervene. Again, 5 minutes strictly, please.
Good morning. I doubt I'll need that much. So I'll start with Dr. Owe's paper. I really don't have a lot of comments regarding yours. It was definitely an interesting read. I only have, I think, one question. So in reading the paper, I wasn't quite sure what your own personal view regarding immunity was. So I understand that first it's a procedural issue and it does not take away from liability, but I wasn't sure what the conclusion to that was. And I was hoping actually before Professor Okafor cut you off that you would, explain that in the discussion, but then it's unfortunate that that didn't happen. So now tying it to that, and then in the paper you also discussed the engagement of Nigeria with the extraordinary African chambers and also the engagements of Canada with the International Criminal Court. So these are both independent of each other. So my question is, how do you propose that this engagement between Nigeria and Canada would go, especially in light of what you mentioned regarding the Malabo Protocol and Nigeria, African countries mostly, deciding to withdraw from the ICC. So I'm just curious as to what your view is regarding how this cooperation would actually pan out. Yeah, and then those are just my concerns regarding your paper, but it was definitely an interesting read. Regarding Dr. Solomon's paper, I thought it was actually really, really interesting. I remember when I was reading some of the decisions regarding the charter, I always wondered, I was always conscious of the fact that perhaps, Nigerian judgments could be this, expansive, So I thought it was really, really interesting, the view that you took. Then regarding that, one of the concerns was that you use Bill of Rights and then you use Charter in your paper. So I'm not sure. So the engagements that you're proposing, are they regarding the Bill of Rights or regarding the Charter? So that's just one of the concerns that I was wondering about. And then, and I completely agree regarding the academic background for Supreme Court justices and all justices generally. And I am in complete support of it. But again, I tend to agree with Dr. Badaru, only because I remember that I used to be in litigation, and sometimes you would see that the judgments were a copy of the final address of the plaintiff, final address of the defendant, and then 2 lines under it saying, that this is what I think, this is the judgment of the court. So if legal education could also be expansive in the sense that it draws influences from journals and textbooks, and then I think it would also influence the decisions of the court. But of course, the justices having their own legal education that is expansive would definitely help. Again, that also speaks to your point regarding the law clerks, right? So if the law clerks also have this legal education, it would help. Then in the paper, this is just an editorial issue anyways. I wasn't sure, okay. I wasn't sure when exactly the Nigeria adopted its own Bill of Rights, because at some point you mentioned that it was 2 years after Canada adopted theirs, 2 years after the Nigerian, and then the Nigerian didn't have theirs until so there was no mention of when we actually, got ours. But like I said, that's just editorial. I think that's actually basically it. For Professor Cheje, I really don't really have. I completely agree with you that it's definitely a case of physician heal thyself. I think Basil talked about it yesterday when he talked about the Trudeau government saying, "Oh, I'm all for environmental rights and whatnot," and then in the same vein saying, "But then we can't starve, so maybe some people." So I think it's definitely um, a conflict, and those are my comments.
Thank you so much, Raina, for that excellent intervention. And so, because we started late, because we're African, I'll have to take 30 minutes from the next panel, otherwise there'll be no time for discussion amongst us, because we're essentially at 11 o'clock. So what I'll do is, because there are only two panelists in the next panel, I'm going to reduce their time, then allocate that time here, so I will have some time for discussion. Otherwise, we'll have to move on straight to the next panel. So we now have 30 minutes for discussion, a general debate. Anybody? Any takers? Okay, we'll do the same thing as last time. We'll take a bunch of questions. Actually, this time, we'll take all the questions, and then I'll give the panelists 3 minutes each to respond.
I thank you very much for your very, very interesting presentations. I have a question for Professor Solomon. I have a comment for Udoka, and I have some information to pass on to Professor Cheje. So, so the question I have for Professor Solomon is, when you look at the way constitutional jurisprudence is developing at the current time, you find out that the reputation that the US Constitution and the US Supreme Court used to have has shifted steadily to the Canadian Supreme Court and its jurisprudence. So I would like to know if in your research you came across any Nigerian case where reference was made to any Canadian Supreme Court judgment, and if so, in what context that arose. If that's not happening, that's probably something that requires some explanation in your paper. Dr. Wee, when you were speaking and you mentioned the ICC, I was telling Professor Kafo, African states, they should all withdraw, all of them. Not a single one should be left there. They should all withdraw. And the simple reason for that is the only thing Africans were guilty of in that situation is naivety. They were very, very naive. They gave their commitment to the world, believing that the court will return that. The world didn't. And that they're justified if all of them should withdraw. I don't like that court. Okay, so for Professor Cheje, I was telling Professor Kafo too while we were speaking. In 2013, while I was still a student here, we just got information one day that our Nigerian judges were coming to York University to discuss how to fight corruption in Nigeria. And it was actually in this Founders College. So I came here. Ordinarily, when they come, I try to avoid them. But on that occasion, since they were judges, I tried to be present. And we fought a lot because what I think happened was that they wanted to come on vacation to Canada and decided to plan in something to make it look like they were here for something serious. It didn't look that way to me because all of them, every single one of them, Federal High Court judge in Abuja, in Nigeria, they were all here with some of the administrative staff. Why I'm bringing it up is not just to complain. That might have been some form of engagement. And since you are discussing corruption, it might be interesting to look at that episode to see exactly what happened. And then...
And the impact.
And yes, of course, the impact. Regarding Manitoba Hydro and Canadian corporations doing business abroad. You probably know that Canada has the Corruption of Foreign Public Officials Act, 1998, that was amended in 2013. Not very, very effective, but it might be some, at least, to show that they are doing something. And if they have tried to implement that act with regard to Canadian businesses in Nigeria, I don't know when Manitoba Hydro's contract was canceled, but maybe earlier this year, I read that they were in the news in Nigeria because the officials were accused of corruption. Manitoba Hydro officials were accused of corruption. Might be something worth looking at. Yeah. Yeah. Thank you.
That's right. Thanks, Basil.
Thanks, Basil. Who else? Dr. Bonolo.
Yes. Thank you for your wonderful presentations. I enjoyed them very much. I have two questions for Dr. Solomon. I mean, one question for Dr. Solomon and one question for Dr. Uduka. For Dr. Solomon, you mentioned that there could be a benefit from the jurisprudence surrounding indigenous people. So what I'm interested in is the context, in particular, considering that maybe here in terms of rights, in terms of resources, etc., they are at a much further place. And when you go back to home, you'll find that it is much of a contest between development and indigenous people's rights. So I'm interested in finding out whether that particular context will not be a bar to actually benefiting more from the jurisprudence of concerning indigenous people from Canada. And then for Dr. Duga, I think you mentioned that there is no conflict between the two systems of immunities and of rights. And I wrote that, and you also said that as a result, there's just a delay. As a result, there's just a delay in terms of accountability, meaning that someone eventually will be punished, not necessarily that they won't be punished. And I think I agree with her that the question then that you should then ask yourself is, why then is the human rights system focusing on punishment immediately? What are the consequences of the delayed accountability? And of course, everyone will be interested in finding out about the impact of the recent developments surrounding the ICC, Africa, the African Human Rights Court, and the Criminal Chamber on the system of immunities, especially in Africa. And for all the speakers, perhaps the question would be, what you all mentioned that there's a potential of engagement. I think it would be also necessary to show, in your opinion, what you think would be the best engagement, or how do you think these are the possibilities, these are the spaces that could be used to foster engagement between Canada and Nigeria? Thank you.
Anybody else? Any other questions or comments? Yes. Can you please hand over the mic to the
Thank you. I will just pick up from where the last questioner left, and just to comment, I am very curious about this question of Canada not being clear, not being coherent, not taking open positions and making open interventions. And maybe this question probably goes to everybody, but more specifically to Professor Ucheje on the anti-corruption question. And then my question is exactly that. If Canada is not speaking, and assume your project was to help Canada figure out how to speak, what would your advice be, or what guidance would you give? Because when it comes to anti-corruption and when it comes to many other issues, there are landmines everywhere. Just to list a few, first, to understand why won't Canada speak up? Has it just given that role to other Western powers? Is it just a safe position to take for Canada? Also, does that mean that, should the conclusion be Canada does not care about human rights, that's why Canada is not speaking up? Or is there another conclusion that can be drawn? What does this silence mean? Yeah? What does speaking mean? I don't know if that's the same question as what is engagement, right? If Canada was to speak, does it have to speak in the same way that everybody else speaks? Or there are other ways, some may be yet to be discovered, that can have good effects? And what would those be? Yeah. There's also the underlying question is, why should Canada care if Nigeria doesn't seem to care? Replace Nigeria with any other country. And in speaking in that context of, surely, are we the ones who are going to care if the owners of a problem don't care? How do you then speak in that situation? But also, does Nigeria have to care for Canada to care? I suppose not. Canada can still care whether Nigeria cares or not, or whether Kenya cares or not, right? So is it possible for Canada to do anti-corruption interventions without, one, falling into China's trap? And China's trap essentially is, we don't ask about good governance, we just do investment. So how can Western powers continue to intervene? How do they speak differently so they don't fall into that trap, right? At the same time, can Canada also talk about anti-corruption without getting into the trap of imperialism, which is, we saw with the World Bank good governance things and IMF and all these donor conditionalities and all that? Is there a way to do it without the donor conditionalities? Will it be effective? So just to ask more, or is that the future of is it a necessary part of the project?
Any other questions? Okay, bearing all that. Okay, yes.
Thank you very much. Thanks for the great presentation, but particularly to Professor Ocheje. On the issue of anti-corruption, I think today is the Anti-Corruption Day, I suppose, as well. But internationally, right? I know, let's take bribery, for example. There's always a supply side and a demand side. And the issue of whether Canada can speak up because they also have, skeletons in their closet. I think if we're waiting for everyone to be, as clean as a white cloth, then no one will speak up against any of the, human rights issues. But my question here is, when we talk about engagement, are we looking at, is it government to government, government to civil society to government, or otherwise? I'm trying to find out if there's any link between, let's say, the NGOs here speaking about how these issues affect the people down in Nigeria, not just maybe government to government, or government to civil society, or civil society to government, or even citizens to citizens. Is there, any? Thank you.
Cloths can be clean. Yeah, exactly. Not just white cloths.
Apologize for
okay. It's okay. It's just a teachable moment. Any other questions? Okay. In the absence of that, I want to raise a couple of mine, and I'll yield the rest of the time.
Sorry, Prof. I know we have a question from social media.
Yeah, please.
To the panel.
I was going to ask you.
Okay.
Question from social media, please.
The person says, since we're talking on Nigeria, I don't know why the person's question is focused on this. It says, is it not important that Nigerian soldiers undergo a reorientation and fine-tuning of syllables to imbue them with tenets of rights?
That was actually one of my questions.
Oh, really?
Yes, in terms
of
so this Canada's engagement with accountability.
Yes, so this person is asking, is it not important that Nigerian soldiers
criminal law and immunity,
and
things like that? It's an excellent question, dovetails with mine, Has there been factual question, descriptive? Has there been any engagement? Because it seems that our security forces have almost no clue whatsoever about the ways in which they're exposing themselves to, and I see it coming, a soon coming indictment, not just, it will go up the ladder, because the brazenness with which they shoot unarmed demonstrators and is now on social media. First it was the Shiites, they massacred hundreds, they massacred hundreds of on video, and I see an indictment. And we don't seem to have any clue that very soon people high up our echelons will be before the ICC. Because Nigeria is one of these naive people that say, we support the international, while they are shooting civilians. We support the International Criminal Court, but you shoot civilians the next day while you support it. So any engagement is interesting that social media was asking that was my first question. The second question that I had, I think also dovetailed with, I think what Obe said, what can Canada learn from the trajectory that you described? Because there's a lot, in my view, that they have to learn from our trajectory, particularly the way we have dealt with our human rights. The courts have, I think our courts have received, even from Nigerian, Solo may disagree, Nigerian human rights commentators, far too little credit for the very innovative ways in which they have dealt with peculiar human rights questions and modified, in my view, some of the jurisprudence, be quite creative. Of course, urged on by the very creative NGOs, right? NGO activists. The other one, Udoka, when you talk about the limitation, I think you clarify later on, but you talk about limitation of competence. You describe immunity as a limitation of competence. I thought maybe it's better to say a suspension of competence. It doesn't limit competence in any way. It suspends it, right? So in a kind of temporal form, and not so much in terms of demarcation of scope, right? Because I think that for non-experts, they often think of immunity as impunity. They often think of immunity as demarcating. You can't try this person, you can't try. No, that's not what immunity says. Immunity says you simply cannot try at this time while they are serving. And there are very good reasons for that. As we saw with Kenya, you can't be going and sitting in ICC and be governing. It's not possible. It's not possible. So we have to balance things. You know, human rights is not some imperialist that must take over I think what point that Solo made, every other policy issue, right? Sometimes we human rights activists and scholars think that human rights must trump everything immediately. There's no other policy consideration other than just human rights. You can't run states like that. And this dovetails my second other question / comment, which is, why are Africans so concerned about immunity? When we talk about, or the lack thereof, whenever we talk about immunity, it seems that the concern is always raised when it comes to Africans. When in reality, virtually every Western leader enjoys immunity in the living law. Can you imagine bringing the British Prime Minister to the ICC? Can you imagine bringing George Bush to the ICC? They enjoy immunity. Immunity is not just what you write. We are looking at law as law that is written on text. Uche, this was your point yesterday. Law is not simply the law on text. There's law as lived experience. The living law is that you cannot try virtually any Western leader. It's impossible, right? So why are we so concerned about immunity? I've never understood it. Unless we think that international law should only apply to the weak, right? And that is the way in which the law tends to function in this international, regrettably, in the national criminal law area. I think those are my few interjections and questions on that. You have 11 minutes to share among the three of you. So one way to share it is 3 minutes basic allocation, then there's 2 minutes for those who need it.
Okay, let me just
go ahead.
get done with mine. Okay, thank you very much for those questions. One of the things as well that was raised when we're talking about immunities is also good to appreciate that there are national law immunities and international law immunities. What we're talking about is international law immunities. Each country decides whether its officials are entitled to immunity from the constitution on paper or not. So national law immunities are different from international law immunities. But Prof, the point that is raised, a very important point, is the fact that, it seems with human rights and the advocacy that we see, it seems as though it's an all or nothing. It is completely accountability or not, and seeing accountability also through the uptake of only criminal, responsibility, without thinking that I made the point earlier when I said there's a common denominator between a system of human rights and a system of immunities, and that's sovereignty. In fact, it is the principle of sovereignty that gives that gives right, or that makes human rights possible. So if you, through a platform, you come on board, you cannot actually just disregard that platform. And very importantly is that immunities is not without value. There's a value to it. There's an intrinsic value, and sometimes we all actually have to look at it, which is why it's a multidisciplinary or interdisciplinary. Looking at the politics side of it and the IR side of it, is that there are other imperatives that have to be considered. For example, sometimes if you look at is it just accountability as against looking at international peace and security as well, looking at stabilizing of international relations. We've also seen, for example, the ICTR in Rwanda. Rwanda did not just adopt a criminal approach to human rights violations. You also have, for example, the gachacha system. If you look at the gachacha system, what was the punishment? Actually, it almost seemed to be a smack on the hand, really. Truth and Reconciliation Commissions and the rest. So there's a gray area. It doesn't have to be an all or nothing approach, but we have to look at and see that there is a value to it. In terms of Rahina saying my view, I thought I had made my view. I said that even in both sides of the divide, the classical positivist view and the naturalist progressive view, what I felt and what I said was that those views don't take into cognizance the dynamics of international rulemaking. And I said they must take into cognizance the dynamics of international rulemaking. And that's my point there. Because if you're saying there must be immunity at all times, then what if you have agreed that your immunity should be removed? If you're bound, you've made that. So you can't just take that position. If you say that there should be no immunity, you also forget the fact that international law is based on consent, and that is the fundamental view. So we seem to, take these positions without looking at the formal sources or the dynamics of international rulemaking, and that's something that I feel is very important. And I think there's also, in terms of immunity, I think Canada can also learn from Nigeria. It's interesting that but Canada can also learn from Nigeria, because the involvement, when we talk about it, we see it from yes, Canada seems to be the one that is going to, teach Nigeria or tell Nigeria. But if you look at the involvement of Nigeria in terms of criminal accountability, exceeds Canada's own experience in that field, while there might be inconsistencies here and there. So it's hoped that at least the engagement will be some sort of knowledge exchange, some sort of knowledge exchange that will go ahead. As to why the human rights system focused on punishment immediately, I don't know, but what is clear is that they might have to wait.
We are live on social media, by the way, on Twitter and Facebook. We have a very important question that was just raised and very relevant to the discussion. Is asking us, all of you, to comment on why Canadian visas take so long to process.
Yes.
And whether there was a way to abridge the time or make the process easier.
Our politics is local.
Okay, I guess that we'll stop the clock at one point to enable him make the announcement. So our 11 minutes will now run again. Yeah. Okay. Let me just. I'm eager myself to say something about immunity, but let me just clear some of the issues raised about my own presentation as far as I can. Which NGOs are funded by Canada, for example? I'm not quite sure now, but I did a small study of Irish law. Irish law is a small litigation group set up by Olisa Bakoba, not as effective as it was in the, say, 10 years ago. But Professor Okafo did a whole book on the subject, so he probably has more information about the funding issue than I have. But your loss was funded entirely by outsiders, and it was very effective for a while. Is judicial engagement a one-way traffic? That's what the question that Professor Bajuru asked. But and Professor Kapo actually also made the same point. He said there are some issues to learn from Nigeria. I talked about that we're not giving enough credit. Yeah, okay, yeah, there are some issues. I mean, we have had innovative application of international law. In my paper, I actually put a footnote wondering whether that was the correct application of international law, but very effective, very effective. And social rights being derived from programmatic statements in the Constitution, Chapter 2, very, very, very nice. You know, so some of those things are nice things that our course have done. Is the impact that I do not quite find as such. Ms. Zama asked, well, I use Bill of Rights, I use Charter. What am I talking about? Well, Canada actually had a Bill of Rights in 1960. It was a statutory instrument, and it did not have any overriding power as such. But despite that, the course didn't make anything out of it. It was the jurisprudence was very highly differential. Not much came out of it. But the Charter of Rights was a very different thing, being a constitutional Bill of Rights. And the cost this time rose to the occasion, maybe because the Charter came at a time when the Constitution itself was being repatriated, and therefore there's a lot of energy in the judiciary, and probably that's the reason why. Probably that's the reason. On court-appeased judgments in Nigeria, well, I can't argue with that. But you know, if you have a small application and you want to enroll an order, you might just take the application itself and paste it and then make it an order of court. You know, that happens. But for longer, a full judgment, cut and paste, that would be terrible. The institution of law clerks is been very useful here. We actually have them in Nigeria as well, legal assistants. You know, I once asked a former Supreme Court judge about what use he made of his own legal assistants. He said he didn't find any use for them at all, but that they usually help him to chase cement allocation and land allocation by the Federal Capital Territory, and so he was using them more like a personal assistant rather than that. But I know some high court judges who have assistants, and they do research for the judges. But their impact is not quite the kind of impact that law clerks have in North America. You know, the famous Oaks test, the proportionality by the Canadian Supreme Court. The story is that it's Professor Obiora's friend who actually wrote that decision for Justice Dixon. You know your friend, Joy Bakan. Bakan was a clerk to Dixon. He wrote that piece. And when Chief Justice Dixon wrote his a biography, he didn't write his autobiography, but a biography was published maybe about 10 years ago. I actually tried to find out whether this judge would admit that. But he said he credited Joy Bakan and the second clerk, I've forgotten his name now, for doing the work, and that it was European based, and they did the work, but he won't admit that they wrote the judgment. So, but I've already quoted or mentioned the irrepressible Richard Posner, who says that there's no appellate judge in America who writes his judgment anymore. These things are written by their clerks, and they just sign off. They sign it off. I don't know whether the late Justice Scalia was like that, but when did Nigeria have its Bill of Rights? 1959. 59. So it's earlier than the Canadian Bill of Rights. Basi wants to know whether any reference to Canadian Supreme Court cases in Nigeria. Yeah, I think I've seen a few, but not the decisive impact that they should command. That's my concern. They are started, I've got lawyers side them, and so on and so forth. I've mentioned that there could be a lot of interaction in the area of engagement in the area of women's rights and minority protection, but the issue of indigenous people's rights jurisprudence is not always relevant to Nigeria, because we don't have a situation of settler colonialism, or having natives being kept in reserves, or having territories. I mean, look at the United States Constitution. Initially, the natives were regarded as being outside the United States. The relationship between the United States government and the so-called tribes was foreign relations. For almost 100 years before the Constitution finally absorbed them back into the United States as such. We don't have that kind of thing. So we may not find that jurisprudence very useful as such. So Professor Okarvo makes many interesting points, but on the military and the security forces in Nigeria, I agree with you entirely. But it's part of the culture of impunity. Take the example, and how we don't take rights seriously. Take the example of the Chief of Army Staff and the encounter he had with Shiites on the road in Zaria. Zaria is a city in northern Nigeria. I mean, at that point, it was just a simple matter of competing rights. The right of the Chief of Army Staff to use a public highway, that is the freedom movement, and the fact that the Shiites were doing the procession and occupying the highway. And so they were kind of depriving others from using the highway. That's just a simple matter of two rights in conflict, and nothing beyond law enforcement intervention. The Chief of Army Staff was going to visit the Emir of Zaria. He wasn't going. This was not a military operation. It was just simply himself moving a convoy to see the Emir. So that his convoy was interrupted did not create any reason to regard it as a military issue that required military response. I think that in such situations, a situation such as that, rather, the Chief of Army Staff should have just found another way or cancel the trip, but never, not for the Chief of Army Staff. Because Nigerians even tell you that, why would you go and confront the military now? You are asking for trouble, because that's the way they see it. Impunity and the killing of the Shiites was not even that day; it was the following day. Yeah. It was the following day, so it was a very terrible thing. I really believe that one day there will be accountability for what happened there, and it's still ongoing. It's not even over yet. Yes, my own comment on impunity, on immunity. I think that is a problem. The problem with the ICC, as I see it right now, is that it doesn't quite have a lot of leverage in dealing with state actors. Let me give you two examples. The first state referral to the so-called self-referral to the ICC was by Museveni. It was to score a political point, to legitimize the LROA and make them kind of international outcasts. Yeah. When the ROC made their own self-referral, it was convenient for them because in the Turu region, you didn't have a lot of atrocities by the government forces. In the areas where you have atrocities by government forces, around there. And so when you look at all these things, you find that the intervention, the prosecutors' intervention in Kenya just exposed the soft underbelly of the ICC, because the case collapsed because you just without state cooperation, it seems to me that there's no hope of any taking any state actor there. And so it becomes, at the end of the day, victor's justice, where the state actors want to bring their enemies like Babu to the court, but you can't bring them to court because they will frustrate you anyway, like Abasha is doing. I think it's an issue. I don't subscribe to the boycott the court, but I think it calls for some reflection about what to do with the court. Thank you. Oh, your turn.
Okay. Just a few comments. Okay. The question is whether Canada is not speaking just because we don't hear it loud outside. But that's precisely what I mean by Canada not speaking. All right? All human rights require active protection from all of the members of the international community. If you respect human rights and you want to promote human rights, but you keep quiet when violations are going on, you're not doing any good to the international community. And people watch what is coming from this side, especially us in Africa. We watch what the stand of the superpowers are on any burning issue of human rights. If they are not sincere, we know right away. And if there's something that we in Africa specialize in, it is in recognizing shenanigans from 1,000 kilometers away. We do. And if they are not sincere, we know. Until recently, Canada, as part of the capitalist world, was promoting corruption in many parts of Africa. And corruption, bribes were being written off as costs of doing business. When they were filing their taxes here, they'll write off bribes as costs of doing business. There was a huge debate about whether Canada should be doing this. But people were of the opinion, a lot of people, and I'm talking about people that matter, were of the opinion that Canada would be at a disadvantage if it was not allowed to do what other countries are doing. The US was neck deep in it, England was neck deep in it, all of them were doing it, and so why the silence from Canada? It is because it is the triumph of the business lobby. That is what is happening. The business lobby will not sit back and allow. Most of these people were sponsored in their campaigns to be part of government by these corporations. And the least they ask from them is, please protect our business. So corruption is not really seen as long as they can take care of their own issues internally, that Canada does not seem to say, or does not seem to want to intervene very actively outside of Canada in terms of anti-corruption. So I think that issue, I think our governments know that. Governments in Africa know that, including Nigeria, that Canada is not a big speaker on this issue. They do fund projects on anti-corruption. I mean, NGOs and so on. And of course, they do fund other projects of development generally, all right? But as far as taking a stand on corruption is concerned, I think our people know that Canada is not a strong speaker in that area. Is there a way to do it without becoming imperialistic? Of course. I mean, just speaking. This is a consequential country. Just speaking once in a while, about the ills that corruption does to developing countries will go a very long way. Because, Canada is one of the big funders. All right? Corruption has led to even armed struggle in Nigeria. Boko Haram, of course, many of us who know the origin of this, we know that corruption is at the root of it. All right? Canada sends peacekeepers all over the world, and it spends a lot of money in that regard. If there is one less strife to be contained, of course, Canada will be the beneficiary of that, because it would cut down the amount of money that it has to spend on peacekeeping. And it spends quite a lot on that one. So the way to do it is at least to complement the things that it is doing on the ground, is to speak once in a while about the ills of corruption and why it is something that developing countries must overcome, and why Canada is ready to support them in their struggle against corruption. But right now, what we see is ambivalence. And ambivalence it doesn't promote human rights at all, because people can see through that very quickly. That was the point I was trying to make. All right.
All that remains for me to do is to thank the panel and urge you to join me in thanking them. Giving them a round of applause, please. Thank you so much.
Thank you.
Thanks. All right, we'll move straight to session 5 on the great People's Republic of South Africa, and also my favorite country. Dr. Bonono does not know that. It's my favorite country, even though I've never been there. But it's still my favorite country of Botswana. All right, so first we're going to have Dr. Moses Foko, who's a senior lecturer in the College of Law of the University of South Africa. He's going to speak on evaluating Canadian, South African collaborative human rights initiatives. And after that, we'll hear from Dr. Ramadi Bonolo Dinokopila, who is a senior lecturer as well at the University of Botswana in Gaborone in Botswana. He will speak on Canadian Botswanan human rights engagements, a critical assessment of the literature and the research agenda. We'll begin with Dr. Foko, please. 15 minutes as usual, please.
Thank you, Prof, for the opportunity. Good morning, everyone. Well, the title of my talk is Evaluating Canadian South African Collaborative Human Rights Initiatives. I intend to proceed with the discussions as follows. Briefly, with the introduction, the research aim or question, the methodology. Then I look at the Canadian approach or attitude towards South Africa prior to 1962 and post-1962. I then consider the South African human rights culture before and post-1994. I then proceed to consider the human rights engagements between these two countries, whether there are any projects that they've worked on together in order to advance human rights. I will not go to the impact, if any, of such projects. Unlike the previous speakers, I will not make a conclusion, but rather a preliminary conclusion, if there is anything such as that. Finally, I consent to be fully interrogated on my paper. And if needs be, I'm prepared to defend it, just like my brother Uche has done. Allow me to proceed. Generally, South Africa and Canada have enjoyed a fairly receptive relationship when it comes to human rights issues. To that extent, our final constitution was drafted from the Canadian, was drawn based on the Canadian Charter on Human Rights and Fundamental Freedoms. It was not a copy and paste, but just to see how they've embraced the idea of human rights going forward. But before that, I don't intend to dwell much on the history of South Africa, but just briefly, it is obvious that the apartheid government devised the so-called divide and rule system, which sought to ensure that black people were denied their fundamental freedoms and other basic human rights. Obviously, this was followed by a torture, massive disappearance of people, etc. And during those days, a parliament was supreme. It could do anything, even killing people without being held accountable. Whilst this occurred, the international community at a certain stage joined forces to condemn apartheid in South Africa. What was Canada's position then? Well, it was during the 1962, Canada made it very clear that it was not interested to be part of human rights abuses abroad, specifically in South Africa. According to it, that matter fell within the domain or territory of South Africa. Therefore, it had no duty to interfere with the domestic affairs of the apartheid government. It was only during the 1970s when the human rights agenda gained momentum in Canada. Well, even before the 1970s, we are aware that there were human rights. But at the 1970s, that's when now they started changing their foreign policy. And more interestingly, they started focusing on South Africa, on how they could assist the country to move forward post-1994. Well, after they've adopted after South Africa adopted the constitution, Canada came up with several initiatives on how it could be part of South Africa's new democratic dispensation that will ensure that various fundamental rights are respected. Let me pause there and go back to the purpose of the paper before I lose you or I lose myself. Well, the purpose of my paper, it was to investigate the Canadian and human rights engagements. How do I intend to do that? Well, the methodology that I've chosen is the desktop. But upon realizing that I was in trouble with gathering information to a limited extent, I chose to conduct limited interviews with certain NGOs to ascertain what kind of collaborative work are they doing with Canada. Colleagues, after 1994 now, we adopted our constitution, the so-called 1996, with fundamental rights. Section 2 of the constitution categorically states that the constitution is supreme and any law of conduct that is contrary to it shall be declared null and void. What are these initiatives, official or unofficial, that Canada has been working together in order to promote the rights? For the purpose of this discourse, I only focused on the refugees' rights, as well as the rights of the LGBTI. Why specifically these rights? While I'm of the view that generally we are a country that respects human rights, but I believe that when it comes to the rights of non-nationals, there is a problem with the South African, I don't know whether government or nationals, but it appears that the protection of these particular rights is not realized, or it's taking some time. As a result, many of nationals, they feel that they are not welcomed into our country. The LGBT rights, there is a problem in that one also, to the extent that even though the Constitutional Court has ruled that no one may be discriminated on one or many grounds, including sexual orientation, but we still have issues such as targeted killings of lesbians and the so-called corrective rape. I must indicate that the jurisprudence of our Constitutional Court, when it decided on this particular case regarding a gays and lesbian, the court largely relied, or rather invoked inspiration from the Canadian Supreme Court's a case. It was Fred versus Albert, if my memory serves me well. Let me specify these particular engagements. Well, there is a so-called a Canadian Foreign Local Initiative Fund. This particular fund, it actually funds several African countries with regard to human rights issues, including South Africa. On this particular instance, the CFIL has funded a project that sought to increase the awareness on the gays and lesbians network, with more focus on rural areas to raise awareness of people with, to raise awareness that people may not be targeted because of their sexual orientation. I do not know what has been the product of this particular project or whether it is ongoing, but I hope that as the time progresses, I might be able to ascertain what impact it has had on the ground. The second project, it was focused on funding the Refugee Project. The Refugee Project, it largely focused on providing some trainings to government officials, raising awareness on the obligations that flows from the domestic laws of South Africa and its international obligations on how to protect and to ensure that non-citizens or refugees are protected in the country. These are the only projects that I have identified so far. But going forward, I say without fear of contradiction that the two countries have worked together and Canada has taken initiatives in many projects. The recent change has been the issue of al-Bashir. When South Africa opted not to arrest President al-Bashir, there was some form of engagement from Canada. Although it was not direct, remember that these are two sovereign countries, so the manner in which they engage with each other at an open level, it's kind of diplomatic. But from those engagements, one can say that Canada was essentially taking a bold stand, trying to condemn South Africa on why did it fail to fulfill its international obligations. My preliminary observations or conclusions in this regard is that despite Canada's initial negative approach on interfering on domestic issues where certain rights were not protected, that attitude changed over the years, and now we can see that it is assisting on certain human rights initiatives. This is evidence from the projects that I've briefly mentioned. Going forward, it is not clear, the impact is not clear, but hopefully I'll manage to give a report on that in due course. Mr. Timekeeper, I assume that I'm still within my time, but that's the end of my talk. Thank you.
Emulate Dr. Moses, please. He's emulatable in many respects, but this is one. One is that he imbibes pints. You all know what pints are. Moses, you know. He imbibes pints. any pints, like me. So I like him for that. So you can emulate him in several respects, but timekeeping is, time management is good. All right, so we'll move on to listen to Dr. Rabadi Bonolo Dinokopila, who would speak to us on the Botswanan context. Thank you. Yeah.
Thank you, Prof. First, let me say I'm very honored to be here. When I received an email from Prof, I was telling whoever could listen that I received an email from Prof, and that finally I get to put the face to the name. So I'm very, very happy to be here. And let me complain that I don't know why I've been put after say here, because my country's letter comes first. We are always trying to fight the big brother mentality in Southern Africa. So I think I'm aggrieved that is being perpetuated here. That notwithstanding, I think my intervention it's very simple and to the point, and it's just to give an assessment of human rights engagement in Botswana between Canada and Botswana, and of course the relations between the two countries, they date back to 1966 when we gained independence. And the rhetoric is that the relations are based on the common approach to commitment to human rights, freedom of expression, the rule of law, and democracy. And I believe that is the understanding that the two countries do have. And like many of the presenters, the affliction that I suffered also is that there's not much literature on the subject. So I had to run around and to try and find out exactly what engagement does exist between the two countries. And I found out that for the longest time, or for a brief period, 1966 up until the Canadian International Development Agency stopped its funding model, we received development assistance, which somehow has stopped. I don't know whether it is because CEDA has been stopped, now they have a different funding model, but I think also it is because of our middle income status, which has seen us suffering more and more, because many countries are saying they can't sponsor Botswana because we have enough. So I think in that context, it is also another point to note that there is no strong presence of Canada in Botswana, and the officials have made it clear that there is not enough human transfer and bilateral and trade relations to the extent that they would have enough to decide that there should be a strong presence. So I think those points, it is against that background that we have to appreciate whatever engagements are taking place between Botswana and Canada. So in my paper, I dealt with the human rights situation in Botswana. And I think it is for two main reasons: to try and establish whether the Canadian-Botswana human rights engagements are relevant, because the human rights situation would show or point to the relevance of the engagement. And secondly, also to have a guideline on when we suggest the relevant interventions or engagement in the future. And of course, just like many other African countries, there are still problems with issues relating to sexual minorities or LGBTI, indigenous people, prisoners. We still retain the death penalty, and it doesn't look like we'll be getting rid of it anytime soon. And abortion is still outlawed. Issues of sex work and disability rights, as well as migrants and refugees, all of these marginalized groups, you find that there's still less protection that is granted to to them. And in the paper, I indicate also when it comes to the plight of indigenous people, a case where the highest court said that you can't enforce socioeconomic rights before the court, because in that case, the indigenous people wanted water, services, health, and the court said no. If you do not have a legitimate expectation to receive such services, then it means the court will not grant you the rights that you are seeking. So issues of socioeconomic rights and consequently social justice, I think they're still a problem. And when it comes to the evidence of engagement, one, there is little evidence to suggest that there is concerted efforts between the two countries. And likewise, there is little literature to suggest that there is enough engagement between the two countries. What I found out is that CEDA has, for the longest time, before it was stopped, and therefore Canada, sponsored a lot of human rights activities, and most of them, they were around issues relating to HIV/AIDS. And then I recall earlier when there was a question about the interest of Canada in Nigeria and why they're interested in certain issues that they were interested in. And I think in Botswana, they are interested in HIV/AIDS because we have a high prevalence of HIV/AIDS infections. At one point, it stood at 29%. Between now it's around 21%. So the interventions are around HIV/AIDS. And then most of the interventions that are around HIV/AIDS are NGO-led. Members of the civil society are the ones who are involved in those activities, which are mostly workshops and mostly provision of services such as condoms and HIV/AIDS testing. And there's not much evidence that the government was involved in those activities. And that was where most of the Canadian funding went to. And when also you look at the time when CEDA was still available, it sponsored NGOs that dealt with public interest litigation on issues of human rights, especially HIV/AIDS and the right to health. There were also outreach programs on vulnerable and orphan children that were sponsored by CEDA and the Canadian government. But all in all, after you see these activities, you see that there's no clear key priority areas that you could point out to say that this, over and above these activities, this is what Canada is interested in. So you would have funding allocated to different NGOs. Some are dealing with labor movements, for example, but you will not be able to get a clear sense on the priority areas. And it is very strange that, well, I suspect that there are Canadian mining companies with investment in Botswana. But it is very strange that it has not come to the extent that the mining economy has been able to provide enough exchange, trade relations or exchange to the extent that Canada will see it necessary to establish a strong presence. And I asked the question in the paper, what are the implications of the presence of Canada in a particular country insofar as the promotion of human rights is concerned? Is there any correlation between Canada's presence and its interest in the human rights engagement in a particular country? And I suspect that if we go further, we may be able to establish that in fact it is, because if they are there, then it means they have a strong interest in that particular country. And of course, the other engagement relates to funding that has been done through the World University Service, of Canada, which they are arguing that they're a key education partner with Botswana. They provide education. They send many students to Canada on key areas such as mining, agriculture, so that they can study here. And of course, they have capacitated several NGOs. And when it comes to the students actually returning to Botswana, they argue that it's 92%. But I suspect that the number is lower than that, because most of the time they don't come back. Most of them, they stay here, including those who are funded by the government. And it goes back to the issue that was discussed yesterday. What really does that mean? Is it an economic decision, or is it one of the ways we can indicate that there's a Canadian, in this case, Botswana, engagement? So, well, in the end, I found that there is not much, but I suspect that if we do an empirical study, and I sit down with the various, the government in particular, and members of the civil society, then I'll be able to get exactly the extent to which Canada and Botswana is engaged in human rights. I must add that what I also found interesting is that I have not come across any where Canada indicates its support or anything to the contrary when it comes to indigenous people. Because in Botswana, the Basara, or the indigenous people we have, it's such a big issue that Survival International, the UK, the US, and other countries are involved. And somehow Canada has not said anything. And I'm yet to find out exactly why they have decided to distance themselves from this particular issue. So I think that's the little I could share with you with respect to Canadian Botswana human rights engagement. Thank you.
That round of applause was rather famished. I think it was because it's closer to lunch, but okay. Second round was better. Thank you so much. I'm almost ashamed that the Nigerian panel, or Nigeria panel, went over by 45 minutes, ate into the time of our South African brothers in this case, and that even within their constricted time, they still yielded more time. What does that tell us about Southern Africa? Does that say anything about why Botswana is a middle power and Nigeria is not, despite having by far the hugest economy? Middle economic power, I mean. Probably even middle military power as well. Anyway, I'm only consoled that when it comes to soccer, we're still number one. So we'll move on to the discussants. Please, can people give them microphones? First, Ms. Halima Doma Kutige, who's a lecturer at Nasarawa State University in Kefi, Nigeria, and Ms. Nkechiene, who is with the Ministry of Justice in Nigeria. Halima, just give her the mic.
I'm here. I have a mic.
Okay. Okay. Go ahead.
Okay.
5 minutes, please. Everyone.
Okay. Thank you, Prof. I'll start by commending the presenters for very good papers, both of them. But by way of contribution, I'll just say briefly, I like the way that Moses started his paper. He gave a brief historical background of human rights history in both Canada and South Africa. And he brought out a similarity that they share to an extent some sort of history. In South Africa, from autocratic racial governments, and then Canada, from parliamentary supremacy to human rights compliant countries. I also liked the fact that he admitted the support hasn't always been there, especially when Canada decided not to support an end to bring in an end to the apartheid government in South Africa. So I found that very interesting. Also, the fact that he agreed or he acknowledged the fact that there's scarcity of literature. Both presenters anyway said that. And from previous presentations that we have had so far, that seems to be the position. So, and Moses's idea that we move from, what did you say? Suggested a hybrid approach is a good suggestion, but I was wondering if we were to embark on a hybrid approach, who are the researchers that will be used? And do you think there is need for some form of training on other methods for those researchers that will eventually evaluate such engagements? And another contribution I want to make to Moses's work is, I don't know if I should call it an abdication of duty, because there's a major engagement that you did not discuss here. In the course of reading for this conference, I came across at the CEDA website and also the Canadian Bar Association website that there has been a major engagement, I think dating back to 1995 or so. And it was huge because CEDA awarded $4 million for that project. There was a project in the area of Canadian South African Constitutional and Legal Development Project on public interest litigation. And I feel it's important to this, your work, because the impact is there. The engagement was huge. They committed a lot of funds for that engagement to start with. And then there was a participation of professionals. At the website, it says over 200 professionals involving academics and judges and lawyers that contributed by way of resources, legal research. And the impact was felt because some of these cases that were litigated reached the Supreme Court, and decisions made were able to impact positively on some aspects of human rights in South Africa. So I think for that purpose, to be good for you to maybe check that out and see if you can include it in your work. I think that's all I can say for Moses' work, but well done, it's a good paper. And then for Ramadi, your paper too was good. I just have one issue. You said that there are engagements, commercial trade engagements between Canadian companies. I think there are Canadian companies in Botswana and the area of mining. You know what comes with mining. There are a lot of, you talk about environmental rights issues, you talk about health issues, and then of course the issue of the place of human rights in business, which is a trending issue now. I thought you would have followed that more than you did, because you said simply that there are no engagements in that aspect. But I wonder if you try to find out if there's a sort of bilateral trade agreement or arrangement between Canada and Botswana, and then maybe if you had checked some of those companies, mining companies, to find out if they have some sort of corporate social responsibility that's involved in the contracts. And that's all I have to say. Thank you.
Hello. Thank you, Professor Bira, for this opportunity. I must commend the presenters for a job well done. With respect to the presentation about South Africa, I must say that when I waited for the papers and Up until yesterday morning, they weren't uploaded. But prior to that, I had done some research on the topics. I came across some what I would call engagements from the Canadian government in South Africa, which Moses did not mention, which I would like to mention because they are critical and important for this discourse. Much as he said that there was initial reluctance by the Canadian government with regard to supporting them or intervening in the apartheid situation then in South Africa, I am glad that eventually Canada made a U-turn. I don't know if you're aware that Canada played a major role, I guess is post 1962 or post 1994, as the case may be. Canada played a major role in South Africa dismantling the apartheid system, and Canada went ahead to promote the establishment of a multi-ethnic, multiracial, and a democratic society in South Africa. And also, Canada supported South Africa's re-entry into some multilateral organizations, including Commonwealth Ministerial Action Group, CMAG. And this particular organization investigates allegations of serious and persistent violations of human rights and democratic principles, and recommends measures for collective Commonwealth action. You mentioned some of the Canadian fund local initiatives by the Canadian government, and in the course of the research, I also came across some other uses of the CFLI funds in South Africa, which you didn't mention. And I think they're also important in order to show to what extent Canada has engaged with South Africa. And those are one, through the funds, they promoted human rights through community radio. That community radio was set up as a platform for change where through it there was promotion of women's rights, LGBT rights, and rights of people living with disabilities. And the second engagement was with respect to improving response to, that's part of what they use the CFLI funds to do in South Africa, was improving response to rape and gender-based violence through response system and training. I would say that Canada does not, irrespective of these things that you and I and Halima have mentioned, I don't think that Canada has much visibility in South Africa and Botswana, just like Dr. Bolonla has mentioned, unlike what the level of visibility that UK and the EU have in other Anglophone African countries. I give you an instance, like in Nigeria, you have a plethora of literature of UK engagements with Nigeria. Remove the fact that Nigeria was colonized by the British and all that. The EU has presence in Nigeria, and a plethora of literature to evidence their engagements with Nigeria. So I really don't know if Canada, like, can't remember the professor that said yesterday or this morning that Canada is a bit reticent with, maybe Canada is a bit reticent with issues of engagement with Anglophone countries, or they don't have the manpower to document some of these engagements. And you could also look at it from another angle, and I ask the question, why does Canada not have visibility in some of these Anglophone African countries? Could it be that the problem is from the African, the Anglophone African countries? Because in Nigeria, there is what we call, in the process of engagement, there is what is called, there are expectations from the UK and the EU on Nigeria, and such things are like counterpart funding, because the UK and EU, they've come up with a lot of reform initiatives, especially in the justice sector in Nigeria, like the setting up of the justice reform team, the law reform commission, the speeding up of the criminal justice system in Nigeria. And Nigeria does not just wait for these things to come. They don't wait to receive. There are expectations on their own part. So in that regard, the set apart counterfund funding, it is a prerequisite on the part of the donors and all that. So Nigeria ensures that it provides a counterpart funding. So I'm asking, are there things that Canada expects from either South Africa or Botswana or other Anglophone African countries that Canada does not have much visibility in? That's when you compare it with other things, other engagements from other part of the Western world, like the UK and all that. Okay, 1 minute. Then I would have been, with regard to the presentation, wonderful presentation by Dr. Bololo, Bololo, yeah. Yes, I would have been surprised if you didn't mention death penalty as one of the human rights. I would have been really, really surprised if you didn't mention that, because when I saw the two countries that were put together in this session, I wondered if Prof, actually it was by design or it was by coincidence, as much as in Southern Africa, but they have a standoff with regard to their human rights, extradition, and death penalty. There is a standoff between the two countries. While South Africa is an abolitionist country, Botswana is a retentionist country with regard to death penalty and all that. So, and it's a human rights problem. So I think at that point that Canada can actually step in as a point of entry to, orchestrate like an engagement to see. I know constitutional amendment is not an easy process. It usually takes long, but we can see that as a point of entry for, engagement in the two countries. Thank you.
Thank you so much to the discussants for those incisive comments.
Sorry, I forgot something. This is just minor. I saw it in the paper. Usually before. Hello? Okay, you used an acronym, WUSC. Usually, in such write-ups, if you want to use an acronym, you first of all have to write it in full, because I saw it in the middle of your paper, and it was actually towards the end that I now saw the meaning of WUSC as World University Service of Canada. So please note that. Then you also used an acronym, CESI. All through the paper, you use CESI, but nobody knows the meaning. I did not see it, anywhere in the paper. So you just take note of that for subsequent presentations. Thank you.
Okay, thank you. On that editorial note, we will open the discussion up to everyone, and we will have about 35 minutes to 37 minutes for that discussion. People are hungry. Lunch is here, but we will defer our engagement with the food until we have engaged each other on the topic of the great People's Democratic Republic of South Africa and my favorite country of Botswana. Okay? So any questions? I see that Obe has already grabbed the microphone in traditional Yoruba style.
No,
yes.
No, I have.
Okay.
I have.
Dr. Obolua Badaru.
Thank you.
My student in whom I'm well pleased.
My professor in whom I'm well pleased. Thank you both for your presentations. I have a particular fondness for Southern Africa. So thank you both. I enjoyed your presentations. Well, I don't know if this ties to the paper directly from the paper was presented on South Africa, but you started off by saying that generally South Africa is known to respect and protect human rights, but with regards to those of who are not citizens or who are not South African citizens, it's not, it's not at par with the way it observes it with its own citizens. And I thought you were going to go and discuss a little bit about xenophobia in South Africa, because I thought, I mean, this is a parallel, and I think it might not be something that has been engaged with directly, but it's a good way to draw parallels if you're looking at Canada and South Africa. Because if you look at Canada, Canada is a country that really kind of invites and accepts, immigration, and we can discuss how things have changed, but to a large extent, it is very clear on how to immigrate and to Canada. But when you look at the attitude, albeit maybe there's a little bit of the undercurrents of maybe not welcoming people, generally that is not very prominent. In South Africa, that's not the case. It's very prominent if you see the way that foreigners are generally treated in South Africa. And I wanted to ask, is it something to consider how the two countries have approached the issue of human rights of foreigners, and how even the society has accepted, foreigners, moving to their countries. In Canada, it's straightforward. You just have to meet the rules. In South Africa, and I was in South Africa, it's very difficult to even get a work permit. It's very, very difficult to access, the Office of Immigration and those. So I'm thinking, is it possible to look at Canada and look at how it has accepted, how it has worked out these rules and engage with that? I'm just looking at those areas. Thank you.
Thank you. Any other questions, please? Any questions? Yes, Yunena.
Thank you, presenters. I just want to know, why did South Africa abolish death penalty, and why Botswana wants to have it abolished?
Wants to have it? No, they don't want.
Botswana retains it, yes.
Okay. Alima, yes.
I wanted to just make a smart answer. Maybe it's because South Africa is retaining it, that Botswana is insisting on abolishing it. Or the other way around, sorry. Sorry, maybe it's because South Africa is abolishing it, that's why.
Okay. All right, any other comments? What about from Zambia? A regional comment, no? No? Comment, question? We have to engage. Please suspend any thoughts about lunch for now until we have engaged with this topic. Yes. Anyway, let them respond to these three while you collect your thoughts and think of other questions. Over to Dr. Foko and Dr. Bonolo.
Okay. Let me first start with the last question. Well, with regard to the death penalty, well, the basis for abolishing it was that it was a degrading, inhuman treatment. Yes. But more to that, mostly were black people that were hanged. A short answer. Well, the issue of xenophobia, I think I did highlight when I started that although there are several human rights projects, but my main focus was particularly these two, given the current or recent events that have been occurring on non-nationals as well as gays and lesbians. Perhaps I was not willing to go more, to say more, but I thought the picture is well known. Anyway, let me not give another paper, but answer your question. I think if you look at the project that I mentioned, where in Canada, this CFLI has been involved, they were training the government officials, church leaders, and other communities, senior community members, on how these rights should be protected. And if you look at our administrative infrastructure, domestic laws dealing with non-nationals, and to a certain extent you try to compare with them Canada, you will see that on paper we have good laws. You go to the offices, everything is there. But where the problem lies, I really don't know, but I can just speculate. I think one of the problems that is affecting South Africans is that they are not used to travel. You know, they've been comfort for too long in their own zone. So when they come across with outsiders, I mean, even in your own home, you feel more comfortable if you are within your surroundings. Immediately when an outsider comes into your own space, you become a little bit uncomfortable. So I think that's a major problem. How do we deal with this a social evil? It's something that you cannot achieve overnight, but we are working on it. It's not easy. It's a huge challenge. Even some of the leaders, they go openly and start throwing unfortunate statements. So it's something that will not be achieved overnight, but it will take some time. Unfortunately, that's the case. That's my short answer. Please, you are welcome.
Take microphone, please. Remember, for taping, you need a mic always.
Sorry, I'm happy on this point. What my point really was not to condemn or to kind of just castigate South Africa. What I'm thinking of is integration. I think that was the word I was looking for. Integration of foreigners, and I think that much as we may pick out issues with Canada's immigration, it does well to integrate. You can learn French, you can do this, when you first come to Canada. So I was thinking maybe that could be, South Africa could draw lessons from that, especially since there's already an established pattern of engagement, and maybe this is just an area of research. And since I think this morning we highlighted the fact that if something is not there, research can throw it up, and if you research into these areas, then it becomes, there's a focus, there's a spotlight on it, and perhaps it can transform into something. I'm just throwing this maybe as a future research agenda.
Okay, there's a response from Professor Power.
Oh, okay.
On this particular issue.
Okay.
Come to you.
I don't know that it's necessarily a response that takes away from the speaker speaking to the issue, but I think I don't want to say challenge, but maybe push you a bit on the idea that Canada does well with integration. I think the experience actually points to the contrary, right? I mean, you've seen Black Lives Matter on the street, for instance, in Toronto. Canada has always done well in terms of its international sort of PR to say that they are better than the US. But we've seen that. We've also seen a Black police chief in the city of Toronto actually defending Cardin, right? Which is something, I mean, I could go into a lot of other things. If you, just last week or 2 weeks ago, there was a talk here on racism on actual Canadian campuses, and it was done by Melinda Smith, who brought out a lot. I mean, the problems in terms of integration and Canada being held as a standard, it's just, I wouldn't do that from all the evidence. I mean, and if you sort of even look at Canada's relationship with its indigenous population and its indigenous people, the sort of horrible human rights record that is there. And yesterday I missed the question period when, the prof was talking about health, women's health and all of that. So I don't really know that Canada would be that example to draw from in terms of South Africa. I mean, I think the problems in xenophobia in South Africa, we could talk about them sociologically as, because I'm very sure that the Black population in South Africa is still reeling from apartheid, and especially when people are still struggling economically, in a place where other people that come from other parts of Africa can actually get more into it. It's similar to the US situation where people are weary of hiring Black African Americans, but are more likely to hire Africans to sort of do the diversity bit, because of there are all these kinds of very interesting but deep-seated racial tensions. But I think my intervention really was just to say, no, Canada does a good PR, and if you are not, before you get into Canada, and before I came into Canada, I had the best sorts of pictures about Canada until I got in here, and a lot of my sociological research and evidence on the ground actually just shows that, no, really, not really. I mean, Canada still even has a gender pay equity gap. And so when Trudeau is running around being the feminist, international feminist, it's just amazing that, every year women in Canada make $8,000 less than men. And I think that was a rant, sorry.
Rants are encouraged here. So we'll go back, we'll continue with them, finishing this round of questions. That was just, intervention. So finish that round.
Well, as I said earlier on, the system is there. Even from the point of entry, the system of integrating non-nationals into the system, even at the local levels, it's there. The question is whether the people who are placed at those particular points of contact are willing to discharge their duties. I think it's the other way around. I mean, my wife is a Kenyan. If she has to go through the system, either updating the papers and so on, I literally have to stop from going work and accompany her because the people are not interested to deal with foreigners. You go there, it's it's tea time, they stay with their cups, they are laughing, sharing jokes. You leave your papers, 3 months down the line, you come, they've lost your papers. It's a mess, but the system, it's there. People are not interested to implement it. So what must we do?
After this, let them deal with this first.
That's my short response.
Yeah. On this point, wait. Wait.
It will finish it.
No. Okay. No. Let them finish with the questions.
Yes.
We'll take another 3.
I think there are several questions that were raised. One is why is Canada not visible in Africa? I think that's the question that kept on popping up in my head as the presentations were going. And the question being whether really are we asking the right question? Shouldn't we be asking whether it is enough what they're doing? And then the other issue is that is there anything that we are expected as Africa to do that we are not doing? I don't think as Botswana there is anything that we are not doing. Not to gloat or anything. And I think in terms of our record, if at all they were to say we need to have a good human rights record for them to do something, I think we are doing all that normally the Western countries would expect us to do. So I think at the end it's a matter of the bottom line for Canada. And they look at Botswana and say, exactly, is there anything that we are getting out of this continued presence and engagement? If there's nothing, then the chances are that they will not invest too much. The death penalty, I think that one it's complex because the society is so much in favor of the death penalty, and it's one of those instances where public opinion has greatly influenced the decision of the courts when it comes to them outlawing the death penalty or finding ways on how to deal with it. The presidents are afraid of putting up a moratorium on the death penalty because they're afraid of losing elections. Yes. So in the end, as far as last year, we are still hanging people. And I think now, I was telling one NGO that perhaps now the focus should be on us finding alternative ways of, which is a bad thing, but of enforcing the death penalty because it's there. Because hanging, I think, it's cruel. But you go to South Africa, there I want the death penalty back. And the Botswana are always laughing and telling them that they're not serious. And then when it comes to extradition, it's complex because people, they kill, they run to South Africa, and then it complicates the diplomatic relations between the two countries. Well, are we going to have any constitutional review anytime soon? I don't think so. I think it will take a very, very long time for the death penalty to go away. Mining and engagement, I'll look into it to see how far bilateral or trade relations between Canadian companies and Botswana companies insofar as mining is concerned, and then look at their corporate social responsibility initiatives to establish whether they have any bearing or impact on Botswana Canadian human rights engagements.
Thank you. Next round, Professor Cheje is on the line. I know that Dr. Baradu wants to go in as well. Maxwell. So let's start with, in that order, and then Jake. Huh? Sorry?
Follow-up
Okay.
answer. To add on what my brother from Botswana has said, the issue of visibility of Canada in South Africa, if you look at post-1994, and during the drafting of the Constitution, Canada's role was very clear, and I think it was visible. But as the time progressed, I think most of the donors, not that I think, it's a fact, they are starting to pull out from South Africa because they are now saying we have reached a stage where now they can see we embrace these so-called human rights, democracy, and the rule of law. So I think that's also contributed to them not being that visible as they were before. Okay. Thank you.
Yeah, Professor Cheje, please.
Okay.
Take a bunch.
All right. No, I'm actually surprised that we are surprised that the attitude of Canada to human rights engagement is the way it is. You know, this did not start today. It's been on for a very long time. Canada was one of the signatories to the Universal Declaration of Human Rights. But with particular reference to South Africa, I wonder if we know that the system of segregation of people to the homelands and then them needing permission to come out was borrowed from Canada here. It was borrowed from Canada. The system of reserves, you know, which is still here with us, was borrowed from in South Africa. Was borrowed from here, you know. So it's a pattern that we can see. You know, Canada comes out powerfully initially in the company of others. The South African cause was a very important cause, and every Western country worthy of its name wanted to associate with it to be seen as a progressive. And then when all the chips were down, they are now pulling out gradually and accusing South Africa of all kinds of things. Oh, that place is corrupt. Oh, the people who are running the government, they don't cut it, and so on and so forth. Well, it all boils down to, why did you get engaged in the first place? Why? Was it because they thought that South Africa would immediately become Canada when it became independent? Well, when we had this new dispensation that came in with the end of apartheid, would South Africa immediately become like Canada? No. You know, if you were going to stand with the people who are challenged with the implementation of human rights or protection of human rights, you are going to go the whole hog and be patient with them. We are just, in Africa, we are just beginning to learn the ropes, all right? And there are so many things ranged against us that would not make our own protection of human rights perfect at all. Well, it is not even perfect here, as many people have pointed out. And so to accuse us of not doing this thing as quickly as they expect, it's like hypocrisy to me, you know? And the whole point of all this discussion is to ensure that we point out this dissonance between pronouncements and action. I mean, Stephen Harper gave one of the most impressive speeches in the United Nations in 2014. And everybody clapped for him. And they said, yeah, Canada has returned. Well, what did we see after that? You know, so it's a pattern that we can see, and it is our duty to point out this dissonance between pronouncement and action to the end that Canada will clean up its act. Thank you.
Thank you. Dr. Padaru.
So I have 2 points, just a minor point, just to respond to Dr. Bauer. And I think, well, maybe when I posted it, it was, you are thinking of it from a sociological perspective and the lived experience of immigrants here. I was actually thinking more of it in terms of even the official policy and implementation, because like if you come to Canada now, you want to go and get your SIN, nobody's gonna keep you waiting. They have to abide, and to that extent, the efficiency in the system of integration, the official policy, is different from when you go even to the office in South Africa, and then like you corroborated, is a very different experience. So I think in that regard, that's what I was saying. But as regards for those who live here and who can attest whether in practice, as in, with the way the society is run, well, that's a different story. And I do defer to that experience that you have. Now, this is another question with regard, and this is, we are talking about engagement, and we've always been saying, every time we seem to think of this engagement, from Canada to I'm still talking about South Africa. But now I want to flip it and think of how about engaging, whereby Canada can actually engage with the experience of South Africa and learn something. Because I think Professor Chiji talked about the pass system, whereby they needed to get a pass to leave and all that. Now with South Africa, which I see, and you could educate me some more about it. Now we look at the land redistribution, the way it is in South Africa, which is quite commendable, especially when you consider the Prevention of Illegal Evictions Act and how it's doing with the squatters who will move on the land, and then what in effect it means that the government has to sell the land. I'm just thinking about this, maybe remotely with the experience of Canada and the reserves and land distribution, because obviously they were putting and some land was taken. I'm just thinking how to restore the historical injustice. Perhaps Canada can look at what South Africa is doing, because South Africa will not allow a landowner to evict squatters without, from my research, without getting the government involved. And usually the government will not evict them. The government will buy the land from, if they move on if 5,000 people move on your land and take over, you can't evict them. Eventually you have to go negotiate with the government, and the government will buy the land. And I'm just looking at it with my limited understanding of the way the reserves are. Could that be something Canada could engage with and see, because there are still some reserves and native people who are really bitter about the dispossession of their lands.
Yeah, thank you. Let's remember, though, before Maxwell speaks, that our focus is on the engagements, right? Not necessarily the human rights condition in South Africa and human rights condition in Canada, right? We're studying on the engagements themselves, whether there's been engagements, why not, blah, 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 right? Maxwell.
Okay. This is a comment that goes to Moses. And of course, it concerns Canada's contribution and support for a constitutional review in the early days. I remember particularly with two scholars from Canada, Patrick McLean and Craig Scott, did an article advocating for recognition of socioeconomic rights. The title of the article was Socioeconomic Rights, whether they are constitutional guarantees or a rope of sand. I've spent some time, at least 6 months, in the Constitutional Court, where you had an opportunity also to serve. One of the observations that I did make is that while there are very, very strong and robust constitutional provisions, which reflects the desire, the aspiration for reform, for social justice, wiping out the injustices of apartheid. But in the subsequent legislations, and this is something that I keenly studied, in the subsequent legislation, there was a very, very clear attempt to muddle the provisions of the law to ensure that there's no reform in terms of even land restitution. There's a piece of legislation called Land Restitution Act. So that, well, there could have been a good intention, especially on the part of Canadian scholars' contribution, but later on, subsequently, I don't know who participated in the drafting of the legislations. But what I want to say is that socioeconomic rights realization in South Africa, much as there is a lot of writings that praise the efforts that have been made and the success, but I think there is no real success, especially the judicial platform of enforcement. So the challenge therefore would be that if these rights have to be real, if they don't have to be ropes of sand, if they have to be real constitutional guarantees, then I think in future the focus of engagement should now focus on what South Africans really need right now, which is socioeconomic guarantees, whether right to housing, right to food, right to education, for instance. That is my comment.
Yeah, I have some questions from Twitter, but I don't know if I could ask my own question regarding South Africa's engagement with Canada. I find the relationship between South Africa and Canada to be very strikingly robust, especially in terms of sexual orientation and gender identity. In the past 10 years, Canada has spent $330 million, 20% of which has gone into initiatives that promote the rights of minorities in South Africa. And I find that since Canada engages with South Africa on some of these rights, South Africa does a bit more than Canada would expect. For example, the Constitution modeled that of, Canada regards the human rights provisions, but South Africa went ahead to, be explicit when it comes to sexual orientation and gender identity. I think same thing with the UN as well. You find South Africa going very, very progressive, and then when they get setbacks from the African group, So I find South Africa always doing a bit more than what they learn from. I mean, they learn some of these things. They pick it up from Canada, but they do slightly more. Why is that? Because that's very different from what we see like in Nigeria and from other countries. Then a couple of people are tweeting that since 2000, the engagement between South Africa and Canada has deteriorated, but right now it has picked up. Someone said diplomatic relations between Canada and SA have deteriorated, according to the Globe and Mali's Africans correspondent. Canada granted refugee status in 2009 to Brandon Huntley, a white South African who claimed to be persecuted by black criminals. I don't know if you have answers to this, but these are just people's tweets. Someone said in 2011, South Africa's president blasted PM Harper for opting out of the Kyoto Protocol in an international climate treaty. But today, South Africa and Canada seem to be sitting on the same chair on the same issues. What happened? Someone said, until 2012, Canada maintained a visa ban on ANC leaders, requiring them to apply for special exemptions if they want to visit. If they want to visit, that's where they stopped. Maybe Canada, I suppose. What has happened since then? Someone said, Canadian diplomats were conspicuously absent from the centennial celebration of Mandela's political party. Have they improved? So I don't know if you have.
These are tweets.
The last one
on social media.
Canadian diplomats were conspicuously absent from the centennial celebration. I don't know what that is. Centennial celebration of Mandela's political party.
Yeah. So this is a global conference. You're here, but you have a global audience that are tweeting, listening to you. That's why I tell you have to be of best behavior. Okay. All right. Over to the panelists to respond.
Let me start first with that question, my sister, just briefly. I think Canada has nothing to learn with regard to land issues from South Africa, because the land still remains with the white minority. Blacks have benefited nothing. So they have nothing to learn in that regard, unless South Africa does something with land reform. Moving forward, my brother, I will only limit myself to the questions on the discussions, not the political ones. I've realized that there are also political questions arising from the tweet.
You don't want to engage with tweets.
Why South Africa? I will leave that to the politicians.
Actually, no. Actually, someone just sent a tweet now saying the South African government openly flouted ICC and their own courts by allowing Omar al-Bashir defy arrest in 2015. Does this have to do with any relations with Canada?
Well, to start with that one, we embrace all forms of justice, including reconciliatory justice, not only punitive justice. I think I've dealt with that one.
No, after the finishes.
Why South Africa always does more than what Canada does? Well, at times you don't know what happens on the political discussions. Because if you look at the issue of gay rights, I fully agree with you. We want more than necessary to ensure, not more than necessary. It's something that good we did. But the contradictory now, about few months ago, South Africa voted against the appointment of the special rapporteur on sexual minority rights. So you ask what is happening there? You contain this clause in the constitution, you fully embrace it. Few years down the line, you're supposed to support something similar to what you have done. You take a different course. I don't know. Maybe the politicians have answers. Regarding the gentleman who claimed that he was no longer safe in South Africa and he came to seek refugee status in Canada and eventually was granted. Well, to be honest, I think that some of the countries are only interested in South Africa because of a certain population. Once that population is no longer there, I doubt that the kind of interest we are seeing will be there. Or certain rights, such as the land issue, is fully addressed. I don't know. Maybe the approach of the Western countries towards Zimbabwe will also be similar to South Africa. Because if you look at that constitution, which was copied and pasted from Canada, it actually protects the land that was unlawfully taken from the black people. So justice, fairness, I don't know. We are human rights lawyers. I don't know. Maybe it does exist. But that was a political issue. And once it was addressed, that refugee status was revoked and the guy had to go back home. He's safe now home.
He's safe now, eh?
Yes. Well, the issue of ANC celebrations and so on, I don't think I have an authority to answer that. But it's a choice. It's either you go or you don't go. When people celebrate, you are not obliged to go. Thank you.
Dr. Bonono.
Yes. No, I don't think I have anything. From most of the questions were directed to my colleague here, Dr. Pog. But I think what Prof earlier on said, that we must ensure through this project that we highlight the dissonance. I think it's a very, very important and critical thing that we must attempt at least to do, so that by the time we some of the answers why Canada seems to be disinterested in Africa and doing the barest minimum, I think we need to. I'm interested in the answer.
All right, we have 2 minutes to lunch. Only 2 minutes between you and your lunch. But that is enough time for another question, or perhaps more tweets. Okay, Professor Cheje. Yes. Please, rush your mic to the learned professor, erudite professor.
My question is about post-apartheid redistribution, justice with relation to land. In Canada here, either through judicial pronouncements or through negotiation, Canada has been paying a lot of money to the Aboriginal people for lands that were seized from them. I don't know if that is going on in South Africa. Is there any compensation for land seized?
Very good pointed question, pointed answer.
The initial approach was the so-called the willing buyer, willing seller.